Welcome back, folks. It's good to see you guys again. Now they're still out to lunch. They finally got through the jury instructions, but they're still out to lunch. They left for lunch about 15 minutes ago. And so what we're gonna do for now, we're gonna go over some of the drama that took place earlier this morning. Because I know I missed it. So figure just to fill some time here, we'll go over a little bit of that.
And I don't consent to being called that name.
So this is not live, just for the record.
Paperwork I accept for value in return for value.
Fuck, it's tatted fucking Jedi.
The correct name. It states the name of my client, the straw man. I am not this name in all capital letters. I do not identify by that name, nor do I know that individual.
Oh my God, dude.
Your objection is noted. It's baseless in law and fact, and that is simply a caption on a pleading
That
on
is
the
not my name.
final jury instructions.
That is not my name.
Do you want to know what's rude, bro?
All right,
I
the
don't
record should
recognize that
reflect,
name or-
Mr. Brooks, I'm talking. The record should reflect that at 3:23 p.m. yesterday, all of the
That's
verdict
fucking
forms were
rude,
printed
homie.
off and provided to Mr. Brooks. I also provided him with an excerpt from the bench book on closing arguments. I left a copy on the state's table as well, and a second copy on the defense table today as well, so that I thought that would be helpful information as we are about that time in the proceeding for the parties to give their closing arguments. Of course, prior to that, the court will be reading through the final jury instructions. The parties were also given the updated version following the jury instruction conference yesterday as well. The total number of pages for that is 107. The court will be reading from the first
I don't know if he
73 pages this morning.
Oh
I do
my
anticipate having to take
Dude,
one or
that
two
73
breaks before
pages
I
took forever.
complete
Can you
all of that.
imagine if he was allowed in the courtroom during
My
that?
plan is to do that.
Talking about.
And then take the lunch break.
Hey.
And then when we come back from lunch to have the parties provide they're not opening, their closing arguments. And then following the closing arguments, the court has the final jury instructions, which go through the closing instruction, instructions 460, 484, and all of the verdicts. And then the instruction to the jury 515 about the
Yeah,
verdicts needed
graveyard
to be
flowers. He
unanimous, and then,
absolutely
selection of a
would have
presiding juror.
would have
The very
interrupted
last
the whole
page,
time.
107, actually is not read until the close of the case and only following receipt of verdicts or some other type of
I gotta tell you
disposition that would
guys,
result in the conclusion of the case.
um,
It's the instruction after the verdict is received. So
Just,
page 107 is not something that will be read.
I just want to point out real quick that I'm really, really grateful to you guys for joining me here. I know, I mean, there's like attorneys with YouTube channels that are live with this. So the fact that you guys want to be here in my chat means so much to me. I mean that a lot. With the exception of Tatted Jedi, he can kiss my ass. But the rest of you guys are fucking fantastic. And I love you guys a lot. So I really appreciate you being here. I just wanted to let you know that like, you're in my feels. You're in my feels.
Today, as indicated yesterday, I will be selecting the alternates by random selection. We'll use the tumbler and select 3 numbers out of that. But that will be done after all of the instructions are read and the parties have an opportunity to give their closing arguments.
The American dream, Dusty Rhodes.
I accept for value in return for value any documents that you just alluded to. I have not seen them.
Mr. Brooks, if you haven't
Yeah,
seen
we'll
them, that is
fill
by your
time up.
choice. They were
Okay.
provided to you.
Jackie Garnett, thank you. I have PTSD now, Mr. Brooks. I want to make a claim as an injured party. Love you, Blair. I love you more, Jackie Garnett. Thank you.
I had someone do it. had them placed on the table this morning, and any other items you threw in the garbage.
So is that the paperwork that I had to stay here for over an hour for?
Sir, I'm not going to discuss any further what we did during the jury instruction conference. The jury's going to be brought
Jury
out a
instruction
little bit
conference?
later.
There was a conference. We talking
I'm
about
sorry,
the
just
proceedings
call
from
me
yesterday,
Hen.
or after you had
My bad.
told us we recessed
Mr.
for the,
Brooks,
I'm referring to after you called recess for the night yesterday. That's what I'm referring to. I
those
was put in the
documents,
holding cell for over an hour.
Those
because they said
documents
it
that
was some
were in a box
paperwork
that
needed
you
to
that is
built
be-
a fort
correct, sir.
with
You
to
were
hide.
kept there in order for my clerk, who had to finalize 76 verdicts, 2 each, 1 not guilty, 1 guilty, and provide those to the parties.
Is
And
that
so
the-
that's why you were kept there, so those could be handed to you. My understanding
Yo,
is they were.
big ups to that clerk, dude. That clerk had to do all of that, dude. 70, dude, that's insane. Oh my God. Like, dude, oh, I can't wait till she sentences him. I can't wait.
Or I would need a bailiff to confirm for me whether he took those back to his cell or if they were put on his desk because he left them in the holding cell.
left him in what holding cell in here?
What do you mean, what holding cell?
I have to look through his paperwork to see if they're on here.
Oh, yeah, Al Capone's holding cell.
holding
What do you
cell
think,
are you
bro?
referring
What are you
to,
talking
Yana?
about?
Behind the door.
I didn't leave anything in that holding cell. I was just trying to figure out why I was in there so long.
Are those the verdicts?
What's
All
up,
right, he has
CDT?
those. Thank you.
Is this the paperwork that was just put on my? It was paperwork on the desk when I came in. That was on top of my folders.
Mr. Brooks, I know that you were given the opportunity to take them to your cell because that is what I was advised. Whether you did that or not, I don't know.
That's
But they
not what
are
I'm,
also on your desk now.
I accept for value in return for value any documents.
We did discuss all of the jury instructions and the verdicts yesterday.
So what was discussed when I was in the cell for over
There
an
was
hour?
no discussion, sir. The court was in recess. Madam Clerk was simply finalizing the paperwork.
Yeah, don't try to pull that
based
shit.
upon the discussion that was held on the record in open court yesterday.
I was told that I had to stay there per you.
Yes, so that we could provide them
Tammy
to you and you
Dalstra,
would have
thank
an
you so
opportunity to
much.
Take them back to your cell.
But
Should
can
you
they-
wish.
So to answer your question as best as I possibly can, my uneducated ass. To answer your question, it's on certain documents, it's spelled in all caps. So he claims, at least this is what I think. If I could be wrong about this, but that's what I've been gathering, is that he claims that he doesn't spell his name in all caps, so he does not go by the name that she's reading off. He does not identify with being called Mr. Brooks, nor does he consent or know that person. So yeah. His defense is all over the place. It's just he's made nothing but a circus out of this trial and has insulted every single person who went to law school for 8 years, or college and pre-law and then law school. He has disrespected every parent that put these people through college in order to be able to serve as an instrument of justice in our justice system. It's insane. I mean, and it is what it is. I mean, he has the right, he does have the right. Yeah, break till 2 p.m. So we got about 45 minutes. So we're just going to go over this morning's antics. Before this, I was actually going over, I was watching Bullshit Betty. Man, she sure is stupid. Talk about somebody who doesn't know shit about the law. It was fun. there's going to be more stuff coming very soon, people. There's going to be more stuff about Betty coming from this channel. I do not want to speak for them, but I would probably expect something soon from Burnt Toast as well. My understanding is that Jonathan Lee Douchebag has tried to copyright strike Toast for her icon, for her avatar, and that's simply not true. It does not belong to him. He's just trying to troll her, I guess. And what's up, Snow Queen? And what I think is happening here, yeah. The fact is that Monty from the Hannibal and Monty shit show, who's been on this channel, and I'm hoping that he'll join me at some point. But Monty made that for her. He drew it. He's an artist. He made that for her. And so yeah, he JLR can't do that. But she hasn't even talked about Betty or him in a minute, so I don't even know what the deal is with that. So that's a little bit of drama. It's a little bit, but I mean, we're talking about Toast here, so I wouldn't worry too much about her. I wouldn't worry too much about her. But yeah, so anything that I can do to help her out and help Monty out. And it's true, Michelle. JLR is absolutely a weenie. If you take off his baseball hat, he looks to me like a overly circumcised penis. Like it went too far. Like the brists just went too far. You know? Like that's what he looks like to me. You take off his hat and he looks like he looks like the rabbi just got a little overzealous.
Can they have been delivered to the jail?
All right. I don't believe there's any other preliminary issues we
There
need
are.
to address other
Oh,
than
he's just an idiot,
advisement. I
Daphne.
will
Don't
have
worry
for
about it.
Mr. Brooks, but let
He
me
was just
turn
a
to the
moron,
parties and ask if there's anything
an insane
preliminary
person.
to this phase of the trial, which is the jury instructions, the verdicts, and closing arguments from the state. All right. Anything else from you, sir?
Yes, there is. Yesterday, I stressed to the court numerous times about me not understanding the proceedings.
Nobody cares whether you understand or not, homie.
And essentially,
The judge seems to. Like, she
decisions are
seems to
being
be
made
helping
on
you
my
out.
behalf without my understanding or giving consent.
Listen, dude.
The court made
This
various
isn't prom
rulings
night, homie.
yesterday. I made findings.
We don't need your consent.
And ultimately made some determinations. I stand behind the record that was made. I'm not going to explain it further.
So a lot of those decisions
Welcome,
were
Carmel
made
M.
when I
Glad
was
you
not
could catch
present
a
in the
live.
courtroom. I was in the other courtroom,
That
correct?
is true, sir.
It's good to have you.
Is that correct?
The record will indicate when those were made and where you were.
And like I said
I
before,
can't see the record.
I'm going to
though.
say this
How am
because
I
the
supposed to know
chat
what the
filled up
record
a little bit more since I said this. Very, very grateful to you guys for coming to this channel to watch this. There's a lot of very, very reputable channels, even channels belonging to attorneys who know exactly what they're talking about, much more than I do. So the fact that you guys want to watch it here because you think it's more fun or whatever reason, I am very, very grateful to you guys for that. So thank you so much. It really, really means a lot to me. I can't express that enough. What's up, Phantasmagorical? How are you? It's been so long. Yeah, totally. Totally glitter bomb. And oh man, you do not win handle of the day. Man, that glitter bomb is it's now I will say this, glitter bombs are awesome. Like I've seen videos where like there's somebody somebody will set up a glitter bomb, like a mechanicalized glitter bomb, and they do it so awesome, and they do it for with a camera. They set up a camera, like it's really technical, for people who steal packages, for porch robbers, right? And those videos are just so much fun, because that idiot will take the package home, open it, and then glitter everywhere. It's fucking fantastic. So fun.
The record will
Welcome, Mr. and Mrs. and Mr. Steelers.
Sir,
Got to have the Mrs.
the
first.
decisions were made yesterday. I'm not revisiting them
See who wears the
today.
pants.
They need to be revisited, and it also needs to be talked about. Subject matter jurisdiction that has yet to be proven for the record. I'm still trying to understand, Your Honor, how you made a judicial determination.
The glitter bomber. Yeah, that dude is awesome.
On my behalf, which I did
But
not
glitter,
give
man,
consent
that is
to.
evil. Glitter is evil. You
If
can
you
never
say
get it
I
off.
forfeited my right to testify, which I never did. I never said I wanted to. I never said I didn't want to. But that decision was made for me. Also, the decision.
Hell yeah, Tim Tarman. You better believe it.
To rest its case was made for me, which I did not consent to, nor did I say
Glitter is like Bullhorn Betty. You can never get it off.
I was ready to rest, or nor did I say
I should be in
ready to
detention.
rest. I'm trying to understand how all these decisions are being made without my consent, without me waiving any rights. I'm not understanding how, because none of my answers were unresponsive. I just didn't answer the way that Your Honor wanted me to answer. But I stressed yesterday, if I don't understand something, how am I supposed to answer a question that I don't understand?
Mike Roch.
It's not me saying yes or no. And it's not me saying, okay, I want to waive this or that right. And I'm not trying to make an argument with you in any way. I'm just seeking to understand.
No, not at all.
Are made. If I'm letting the court know and I'm putting the court on notice, hey, I don't understand.
I think so.
I don't understand that.
And I bet you anything, at least, I don't know, dude. Like, in theory, from a layman, right? In theory, from a layman, somebody who's not an attorney, and is just fascinated by this case the way that you guys are. I feel like the prosecution's closing arguments are going to be like really fast. Like, I don't think they're going to, I think they're going to just go over simply just like the basics and what needs to be done and what needs to be gone over. And that's it. That's what I think. I think they're so sick of being here, but they're also going to be thorough and make sure that they slam dunk this asshole.
Any other things? Otherwise, I'm prepared to address each one of those.
Yeah. There was a mention of if there is a conviction in this matter, there is a mention of sentencing, which I'm assuming there'll be some type of people may want to speak. I know if there is a conviction on my half, people would definitely want to address the court. There'll be a lot of affairs that need to be put in order, obviously on my side. If it pleases the court, if there is a conviction in this matter, I would like the
I love the
if to not be so quick.
I think you mean when.
I'm asking if it pleases the court for the sentencing to be held off into a later time, not
No, you wasted too much
a
time.
day or two or a week,
Nah, you wasted too much time.
just so that affairs can be put in order properly, and so that the people that want to come in and speak will have the opportunity to address the court.
I think
If
that's
that
a fair
pleases-
request, sir.
If that pleases.
I think that's a fair request. I thought about that some more.
How
when
about
in-
that?
In the event
This
there
judge is a
conviction that,
saint, bro.
I would like to give the parties an
Judge
opportunity
Jenny's
to
a
do
saint.
that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone. If there is a conviction on any of these counts,
When
I
there's a
may ask the
conviction.
parties to just come back in on Monday, October 31st with kind of a proposed plan of how many people do you think will speak on your behalf? How long do you think it will take? So that I can look at my calendar and then set aside the appropriate amount of time. I certainly don't want to.
Alley Cat, I'm inclined to somewhat agree with you, but I'm
Thank you.
also,
All right.
and this is just me,
So
okay?
with all of
I'm
that
in a
then, sir,
place
subject-
now. Let me highlight your comment real quick. In my honest opinion, if the judge would have been a little tougher with him in the beginning, she would have gotten this type of his personality out more. I understand she is trying to squash any type of appeal that, I mean, that's possibly, I mean, you're probably right. Maybe. I'm not inclined to disagree with you. But I like where I'm at in my head now is, what's up, brother Preach? I haven't seen you in forever, dude. Oh my God. It's good to see you. Where I'm at in my headspace at this point is it already happened and now we're here. You know what I mean? And now she has set this tone of an opinion of herself for the rest of us. I don't even know how to word this, but she's more than fair. Maybe a little too light. That's arguable for sure. But here we are, and I think that the end result is going to be, I still have faith in the end result is basically my point. And I think everything that has led up to the end result has been a means to an end so far. It just is what it is. Yeah. So, I mean, I don't know, but I'm definitely not disagreeing with you.
Subject matter jurisdiction, I decline to address that further. I stand by the written decision that I've made previously. As far as the
Ali
rulings
P,
made
Costa
yesterday
Rica.
regarding,
Costa Rica has good surf.
your ability or inability to
Not that
present
I'm
further testimony and
a good
witnesses
surfer. I'm
and
terrible
to
at it,
testify
actually.
yourself. The court
I
did
just
make
know surfers,
various
and they like
rulings
going to
and
Costa
findings
Rica.
that you had forfeited your right to do so by conduct. I'm not going to further explain the law or these prior rulings to you. I stand behind them, and I believe I made a very, very clear record. So to the extent that you are asking me to reconsider any of that, that's how I would interpret your statements here today. I decline to do so.
So, Your Honor,
So Dreamscape, is that a reference to the movie? Because I think that movie is awesome. If you guys have never seen Dreamscape, it's Dennis Quaid's best work like ever.
would that be
Nerd moment.
that's
Sorry.
still not, I have no understanding to why I wasn't given the opportunity to place certain things
Oh, look, Cherry decided to show up and do something.
to evidence. I have virtually nothing, zero evidence that I was able to place into evidence. Nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf.
Yeah, dude.
On various
Were you not
issues,
there?
including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did present evidence.
I'm speaking to the terms of everything that Your Honor
Margot,
asked me to do.
I'll
He
put
told
you
me
on
to,
timeout just to amuse
put
myself.
everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do. I did that.
Mr. Brooks, you may have interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told
You see how she talks to
is
me?
that
She's
any
so
requests
abusive.
that you have related to the case, if
Like,
it's
this
a
is what I have
motion,
to
be
deal
put
with
in
all the
writing. I
time.
specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law.
Look, and then
the
she gets
facts
everybody
upon
to
which the
attack
request
me.
is being made. Again, I'm not going to revisit the prior rulings. I stand behind them, and to the extent that the record.
Do you guys see? Do you see how Cherry treats me?
Does not have, meaning the record before the jury and the evidence does not have certain pieces of information, evidence, or testimony that you wanted to present. You forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that, sir.
How did
What I
I
will tell
forfeit?
you
Oh, I
is
saw that in
How
my
did I
feed.
forfeit
Leave it
that
to
this
Bieber.
jury is
opportunity
here.
to be able to place into evidence
Mr.
things.
Brooks, I'm
See
not
what I
going to
mean?
debate
Always
this
with the
further.
name
I'm
call.
I'm not trying to
asking
debate. I'm
you
trying to understand.
To respect the fact that I've made rulings.
Your Honor, that's you
It's
made
not
a
my
judicial
job to
determination.
explain them
You made
to
it.
you.
I'm not asking you to explain anything.
I would
You're misinterpreting
never
what I'm trying to
platform
ask you and
boots.
trying to
I would
tell you.
never, and I
You're
resent
misinterpreting me.
the accusation
With all
and
due
the
respect,
implication.
When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before
Like, what is
would
the
I have a
point
chance to
of
present
anything
things
that
into
he's
evidence?
talking
You
about
told me
right
we
now?
were
What is
not
the
at
point of him even
evidentiary
bringing
phase
any of
the
this up?
trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things in the evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that,
Yeah, exactly, Michelle.
quite frankly,
to stall. That's all he's doing.
To put on the defense.
He's just trying to burn time.
Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that,
thanks,
I did
love.
what
Thanks,
Your Honor
love.
asked me to do. And these are things that
Abusive limey.
were part of my defense that needed to be placed into the record. So where my confusion comes in is
Totally
not being able
Dreamscape.
to
I
place
agree.
those
I think
things
it's just some way
into the record.
to distance himself.
Things
Mr.
that
Brooks, I'm
things
gonna
that
cut you off
clearly help
because
my defense.
He feels
I
attacked
stand
all
by
the
my
time.
ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the
Mr.
record?
Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it.
You're
with
right. That's not what Cherry sounds like. Cherry sounds like this. Cherry, Mom, bring us another pint. Bring us another pint, ma'am. And do it quick. Before you feel the back of my hand.
With you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks,
I'm
no
just,
longer
I'm
going
just
to
seeking
talk
to
about
understand.
this.
I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or
The
evidence
filings that
or
I
the
filed.
rulings
I'm
or the
asking a
law
question,
to
Your Honor.
you.
I'm merely asking a question.
Yes, Cherry is a proud Scot, for the record. She's a proud Scot, okay, who loves cheese.
Filings that I presented to Your Honor.
Any filings
For
with
the
this
court.
court are in the court record. That does not mean they're evidence, sir. And I told you
That's
that
not what I'm
previously.
asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized, that I presented to the court, all the filings,
Totally, Tim.
the appearance bond.
She's just
the
a
statement
limey
of
Irish
particulars,
Scottish
the
version of
notice
it.
of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
So they were filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told
Mr.
me,
Brooks,
Who doesn't love cheese graveyard flowers? Apparently crazy Scottish people that dwell in their grandma's basement and yell for pints.
Brooks, I am bringing this jury
Your Honor,
out.
with
Listen
all
to
respect, you told me that we were not at the evidence. When I said I have exhibits as well, I have stuff that I want to put into the record. I even asked, I said,
Mr.
may I
Brooks,
give an offer into evidence?
I'm going to stop
these
you
things.
once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It
We
should
are
not
now
be, though,
at the
Your Honor.
jury. I understand your lack of consent, your
So
objection.
when would I be?
The difference between Irish and Scottish, is there a difference? I don't think there's a difference. Oh, I'm going to be in trouble. Mrs. and Mr. Steelers, thank you so much. Every parent has listened to this Brooks nonsensical BS before. Agreed.
Would I
is
be able to
noted
put?
for the
When would
record.
I be able to put vital information into the record, which I haven't had the opportunity to do?
That opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence, filings, and important paperwork and documents.
Mr. Brooks, and you
How am I
forfeited
not-
your right to do that by your conduct yesterday, and I stand behind that decision.
I
I'm going to
asked
do the
before
following,
yesterday,
sir.
Your Honor.
I'm
Allie
going
P,
to do
we,
the following.
before yesterday.
we
You
never
have
fight.
not honored my
Ever.
request to you that you cease debating me on prior
I'm not
rulings.
And
trying to
thank
debate.
you, by the way.
I'm trying to understand why my due process is being
Mutiny.
violated.
Mr. Brooks, the record speaks for
Mutiny.
itself.
No, the record
I am
does
going
not.
to take
it
a
does not.
5-minute recess. When I come back out, the jury will also be coming out. I'm advising you, there will be no multiple opportunities where I
I'm going to drop a deuce because you give me the shits.
give you to conform your conduct to the rules of decorum.
Well, then
courtesy.
just hold me in
You-
contempt, then, Your Honor.
You are
Hold me in
hereby
contempt because
advised
I didn't even. I'm trying to
that if
seek to
you start
understand.
talking about subject matter jurisdiction or any of these other
It needs
issues
to be addressed,
or
Your
in
Honor.
any way
We're not talking
interrupt
about subject matter
the
jurisdiction. We're
reading of the
talking
jury
about
instructions,
why my due process
I
has been
will excuse
violated.
the jury and you will be removed
Your
to
Honor,
the other courtroom.
We're talking about the 14th Amendment,
Right.
Section
I'm
1.
taking a 5-minute break. We are in
Your Honor, I
recess.
don't
When
agree
come
to a
back out,
estoppel. I
Woosah.
don't agree to a estoppel. Your Honor,
Nobody gives a fuck what you consent to, bro. Nobody cares. Nobody cares. Hold on. Let's see where we're at real quick. I mean, we still got so much time, right? Yeah, we still got like 20 minutes. let's entertain ourselves with other stupidity for the moment. Just for the brief moment.
So blue.
God, what a shocker that she has this set to where you can't skip them. Oh my God. Yeah, okay.
Maybe this is something. We'll check it out. We'll check it
Wow.
out.
I'm in it live.
Like, and she gets like, she gets in full on Karen gear too. You know what I mean? Like, does she wake up in the morning and like go into her shit and is like, this? Nothing says Karen like this shirt
She did tell me that. She didn't see the neighbors.
and the lanyard.
Like down the street.
No, what fight? There was a fight? Was there a fight? Yeah, she was just blowing a whole shit ton of hot air, talking about people's rights.
Who was the lady in the shirt yesterday who came out here that Billy Joe was trying to like? That wasn't that was the other lady, right? No, that was one of her friends. And I was thinking, like, even I was just like, I would.
So what are they just like just streaming just nothing, thinking something's gonna happen?
And causing even more problems for our legal. You know,
Get a fucking life. That's how that horn was translated to me.
They can't do it.
Get a fucking life.
But you would think. You would think that they would say, you know, everybody leave this damn house so we can stop being embarrassed on TV and around the world. You know, you would think that somebody with some scruples upstairs would say that, but no, not here because it's the party house. We learned that.
Do you know what scruples means? Not that.
Day one. And they have not proved that statement wrong yet. And we're here 2 weeks later, and it's still the same crappy party house with the same mouthy people that like to get drunk and put stuff up their nose and smoke stuff out their mouth.
You mean like you and what you've been arrested for?
To a 20-month-old child disappearing and winding up in a landfill, and mom being the responsible party. You know, that's how we got here.
Don't give the shot. I think the photo wants to.
Oh my God, dude.
Okay.
So she snorts cheeseburgers and donuts. Oh my God, dude. That's interesting. Hold on.
So we just learned.
I love how she just comes back into the shot, just like
very reliable source that we just found out that Leilani's on double probation. She's on probation from a theft in North Carolina and one here, yes, in Georgia.
Well, actually, you heard that she's on double probation. You didn't find that out. You heard it. Did you do any research? Did you look it up? No, you just hear things and then spew them out.
Why isn't she in jail yet? This is, and we have now she's on double probation. Where was the violation of probation when she violated the probation to get on the other probation?
What?
Like, this is freaking insane. I don't know what I'm gonna do.
You're insane.
Because
you can't have contact.
That's so crazy. Dude, what is in the weed? What is in the weed that Dolly's smoking? Like, I don't understand. Like, I don't get it. I just don't see the attraction. Like, it's crazy to me. What is in the weed that Dolly's smoking? And I don't think I want any, because I might wake up next to the Karenest of all Karens and then just live a life of regret, shame. Just, like, my dick will fall off because I fucking washed it with bleach, and you know, then it ends up looking like her hair, and oh god, man, it's terrible.
But they're going to give you leniency and let you have to answer to somebody else and show that you're trying and this, that, and the other, because Billy Joe doesn't like letting her daughter be accountable. Apparently, neither does the states either. Let's just she's what is it? Because she's pretty, she's got brown hair. You guys feel bad for her. You think that psycho bitches don't come in pretty sizes, right? With pretty bodies or something.
I mean, they generally look like you, but that's not the case here. The case here is that they are building a case, and they are confident in their case, or else they would have not publicly named her as their suspect. Their one and only suspect. It takes time to build a case, Miss Attorney.
Thing like what's going on here?
Is this
what's
what she
going on
does?
here?
She
And we have
she just lets the stream go on all day, because I haven't been watching. Is that what she does? Is like she just lets the stream go all day and then just complains about baseless shit that she doesn't know anything about? Oh, I don't care, Camry 3. I don't care in the slightest bit.
we find out it's double probation, folks, double probation for Leilani. And the police chief he still just can't find anything to arrest her on.
Those are people who think you're stupid. Every time that somebody drives by and honks their horn, it's to disrupt you because you're stupid. That's all that is.
An officer and all this. And Chief Hadley.
And we're just killing time right now, guys. And we're waiting for the closing arguments to take place. So in the meantime, we'll just make fun of this Karen.
Did you tell the probation officer not to violate her probation by any chance? Just curious. Because if you did, another thing I have a problem with you with, right? Like, this bitch needs to be in jail.
Bro, get out of my face, bro. Why are you so close to me?
And you're more concerned about keeping her out of jail and not finding that baby than you are about putting her in jail and getting your ass out there to that landfill and working until you find him. I got a problem with that, buddy.
What a fucking dolt.
Can't the probation officer go into it?
I need to look up those things.
I got a problem with that, buddy.
Guys, I need you guys to start. Can somebody go into? I know.
Did she just take a whack? Hold on.
I need you guys to start. Can somebody go into? I know. People had the records. Sent me. I got been verified and Truth Finder on Leilani. It had a long list of her charges and stuff like that. We need to find out the case numbers. There's the one in North Carolina, I think we all know about, in that I need her probation officer. I need the court records from that. I need somebody to go into the clerk of courts and physically pull
So yeah, let's
the court order
let's Karen the probation officer. Good idea.
of that probation down for me. And I also need you guys to look for the Georgia
Every time
charge that
somebody
she's on
drives
double
by and
probation
honks their
for. I
horn.
also need you to go find the clerk of courts for that county
It's so funny
and
to
get
me.
access to those court records, the order, the final order of that she's allowed to do on or off
10 more minutes,
probation.
guys.
And if you can't get it, if they don't have the systems where they upload those documents for you, give me those case numbers and the information for the clerk of courts, and I will do a record request for those counties when I get back to my room. But we need to get some information. I need to find out who your probation officer is. I'm pretty sure he's been contacted, but just for the benefit of the doubt, right? Just for the benefit of the
just to be that extra pain in the balls, I'm gonna fucking contact that probation officer.
doubt. Maybe they need. I just want to make sure that they know. So the only way I know that somebody knows is if I tell them, right? I don't want to assume somebody's giving them this information. I don't want to assume that they know that one of their people that are out on probation, on double probation.
I didn't eat. I I couldn't decide on anything, and I'm like really hungry, but I'm just not in the mood for like anything in particular. Like I live in such a remote area that like DoorDash is like so limited. And the stuff that's around here, like I could go somewhere and buy stuff and make something. That's not happening today. That's not happening today.
Is accused.
And I've been meaning to lose weight anyway because I joined the gym, so I just opted not to eat.
Of killing her child, and not only that, but has a long history of child abuse in her wake with all of her kids. The only one I'm not sure about is Sky, but how can we be? She's 4 months old. God knows what her little body has been put through at the hands of her mother, and that is a sick woman. Billy Joe is a sick woman. I'm very glad that they did that interview. I'm really glad that they did that interview. I think it really
I haven't watched that
showcased
yet.
how
I'm gonna actually go over that. I actually had a conversation with Morbid Reality last night. So I think we're gonna throw something in the works and deal with this like head on. So yeah, I'm just waiting. I'm gonna go over that interview and all that other stuff. I mean, there's no developments in this case, so eventually I'm just gonna go over that stuff. But it wasn't that productive of a conversation because I was like really too drunk to have it. Like he ended up texting me, and then I called him up because I couldn't type. And I was just like, listen, man, disclaimer, like I am way too hammered to have this conversation, dude. But yeah, but I wasn't too hammered to where I don't remember having the conversation. So yeah, we're definitely going to throw something in the works pretty soon.
how they're failing to take responsibility. I think it showcased that they're guilty as hell. Did you guys? Everybody saw how evil Billy Joe looked. Everybody. She looked, and not only that, but many of you guys know I don't like her, but damn, she looks old, right? She looks so freaking old. It is shocking. I remember the first time before I even got down here, when she did that very first
pot meat kettle
interview, and she's like, I just don't trust my daughter. One where she's standing next to Tom, and they're giving her an interview, and she's crying, and everybody was trying to convince me because I was trying to look up her paperwork, and there was one that was 45, and I'm like, there's no way this lady's 40.
What's really funny is every vehicle that drives by past her is somebody on their way to do something more productive than what she's doing right now. It doesn't matter what it is. It matters not at all, not even a little bit, what anybody in that car, in whatever one of those cars, is going on their way to do. I promise you that it's more productive than what she's doing right now. Like, just pick one of those cars out of a hat. You know what I mean? It doesn't matter what that person in that car is on their way to do. I guarantee you that it is more productive than what she is doing right now.
He's 45. I'm looking for a 60 to 65-year-old lady. And I couldn't find her. And then somebody sent me, it kept arguing with me about it. I have a whole live arguing with my audience about her age because I did not believe she was 45. That means she's only 2 years older than me. And then she goes on that interview and it's like, I'm not wrong. She looks like a freaking old lady, right? That's why your body ages like that?
Dude, I love the troll Annie from 10 to Life. Like, I'll randomly text Annie and be like, and say shit like, hey, do you think Grandma Billy Joe is, you think since she's single, you should be interested? Or I'd say shit like, do you think you think Lori Vallow's got a pen pal yet? If she gets out, you think she's gonna like, if she gets like away with this, is she gonna like date? You think I got a chance? And I'll send that shit so randomly and she'll just be like, I fucking hate you.
That Billy Joe, it's because you put it through the ringer with all the drugs and alcohol. Your skin's sagging, you got wrinkles, you're aged way advanced for your age.
Is she looking like, is the camera like image, is she looking directly at that? Because she's describing herself. She's literally describing herself right now.
That's due to your lifestyle. So don't come out here and tell me how I'm a liar and I don't know what the hell I'm talking about when it comes to your family. I know a lot about your family. I think you're just incredibly shocked that we were able to.
I think you're a liar, but I think you're more of an idiot than a liar. I think the idiot outweighs the liar in you.
Come out here and learn so much information so very quickly. Like, we were able to uncover your entire life in less than a week. We knew everything about you, from your prostitution to your drugs to your
right, because going around and harassing neighbors is the way to get real information. Sure.
Thefts and all that other stuff. We knew that before coming into town, right? It's just a shame. It's just a shame, Billy Joe. You had custody of these kids and you put them right back in harm's way, and you knowingly did. It was acceptable for you. It was acceptable for you. You accepted the risks, knowing that Quentin, his brother, and his sister would be exposed to drugs and violence in the care of his mother. And I'm going to go as far as to say probably in your care too. Maybe that's why it's acceptable for you, Billy Joe. Were you also beating that child?
Yes.
Was that you?
That was her.
God bless you. That was my friend. That's my girl Olivia that was out here with you.
Who was that?
Where's the camera?
They got it on video. I'll be out here spraying.
God bless you. What you want to pray with?
Look, and this verse is just like, I have something important to do, something vastly more important than this, and I just want to go.
Or ripping children out of people's houses because they're poor, so you don't mind paying a foster family XYZ dollars to take care of this kid, but you won't take that XYZ dollars to help the family stay together.
Exactly.
Oh my God, dude.
That's what I think. Yeah, that's what you're gonna do. I hear this story over and over. I've been here. Everybody, I can't hardly talk about it. Comes out here, this local. I've been through that.
be gone.
She
They
is.
know it.
She is
They
the
know
ultimate
it.
Karen.
No, and like I tell everybody, you know, everybody will
Calamity Jade, thank you. How dare they honk in the middle of her vagina monologue? Love to all. Love to you.
You know, let the world know. I got thousands of my friends. And I'm letting the world know about Chatham County. I'm letting them know about the crap I found out. You know,
More like the barren womb monologue. The Karen barren womb monologue.
The bruises on them. How do these women have bruises when they won't resist? Because you were manhandling them. I have a fucking problem with that. And I told the police chief, let's come out here. I started coming out here. Let me see you do that. Yeah, I'm from Florida, but I'm a political activist to boot. So
She's a political activist to boot. No, you're not. Shut up.
I know that's
Quiet. We're going back to. That's Dolly Vision right there. That's Dolly Vision right there. Oh, so I went into Uncivil Laws chat and asked him if he was still going to do the critical K thing. And he said, yeah. And he went into it for a second and he was just like, yeah, well, she didn't show up to court. And I'm just like, yeah, I already knew that. I just wanted, you're a lawyer. I wanted you to explain what the hell that $49,000 things was. So I would love to explain the development in the critical K lawsuit, but I don't understand it. I'm not a lawyer. I don't get it. So yeah, sorry. Wait, did it end? No. Wait, where in the, what in the, okay, here we go. What in the bullhorn boobs?
Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising, as they are meritless.
Meritless.
And I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record to the extent that he raises objections.
Okay, as best as I can, for anybody who knows and has been following the critical K lawsuit, she's being sued for $10 million. But from what I gathered from this latest document that I got, and I'm not going to go over it right now, but it feels like what it's saying is she's ordered to pay $49,000 in like lawyer fees for Ray and hotel accommodations and food and whatever, because they actually traveled to show up for their court date, but Kay did not show up for her court date. So we'll see. I don't know. That's what it's what it feels like. I don't know if that's actually true.
The record
I was about to do.
of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include. It's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. we missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's
Yeah, Hope SC. I don't know if that's like the final ruling. I don't think it is. I think it's just like on top of the 10 grand or the 10 mil that still has yet to be determined whether or not she has to pay. She definitely has to pay 49 G's.
The instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my filings?
You know what? I can give you the print offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin,
Buckle up.
goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday.
Critical K is being sued for
Purpose of the
defamation.
closing arguments is to summarize the facts. Marshall
She
focus the
she
issues
trash
for
talked the
the
wrong
jury. I
victim's
just talked
family
about the order of
member.
the
So
arguments.
yeah,
The scope
I mean,
of
it
the
was a
arguments,
matter of time.
The content,
Bound to
duration,
happen.
and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised. But I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case
it
law
looks
that
like
govern,
BHB behind Brooks. Yeah, but
closing arguments.
the difference is that
Again, Your Honor,
that person has a
without
job
prejudice, I'm here by special
It
appearance.
is-
I don't consent
and
to
it's
be
much
called
more
that name
productive.
for the record.
It's noted, sir. All right, then with that, I will have the go ahead. Looks like Attorney Upper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
It's gonna put it like right here, and then you want me standing at this table during?
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what I-
as,
yeah, that, I was gonna put it like right about here so that he could still see me and the jury.
with that caveat, yes. we'll-
no.
Objection, what is
As a
that?
legal pro, what
It's
she'd be
supposed to
doing is yelling and screaming through a bullhorn outside of the courthouse, getting so much done.
They were previously.
Find him guilty already. You're wasting time. This is not how due
So are they
process
exhibits?
works.
I'm confused.
Just
what they are.
find him
I
guilty.
made a ruling.
Just
the
put
state
him in the
did
prison
request
without
that
sentencing.
Yeah, but
In
I'm
terms
saying
of,
I don't understand what's being shown. Should not have the right to ask to object and ask what it is that's actually going to be shown.
the state's put on the record what it is. They, or I should say,
It's
they
evidence,
are
asshole.
exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So can I put up exhibits?
Um, Mr. Brooks, I don't know what you have planned for your closing argument. So,
I'm making a request, the same request, man.
Can
I'll
I
be able
put
to
up exhibits?
well, I guess it
exhibits.
depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is, once the state goes through its closing, I may take just a short comfort
What
break,
I
depending
intend to
on
do
how
is
long
go
it
home
is.
and pour a mega
Um,
pint.
And if there's something in particular, what are you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously.
Yeah,
It's
Miss
just not
Sunshine, that's
nothing that the
exactly what
state
he's
has.
doing.
I'm not aware of exhibits.
That's exactly what
that
he's
the
doing.
state wouldn't have, that you would have. Everything that's been received, we have a list.
Can I put up
Um,
exhibits?
So if it's not something that was received during the trial as an exhibit by the
This
court,
fool.
unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction.
76
or,
charges.
would not be something that would be proper before this
That
jury.
even
Those are
rivals Betty.
legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings. That
That's
Oh
not
my God,
specific
dude.
enough,
My-
sir. What are you
My
referring
court
to?
docket
Which
sheet.
filing?
Let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done?
Wow. Wow.
Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What
Your
filing
Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I didn't know if you was gonna say something else.
I've asked a question, sir, so when I do that, I would hope it would convey to you, I'm looking for an answer. So which filing are you referring to?
All
With
my
specificity.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How's it not relevant? Not even your
That's my
oath of office?
determination, sir. So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
So I don't know for sure.
explain
Uh,
why that's
There are
not
people
relevant?
there are people in this chat that would know better. But the Wilson Dallas, you're screaming contempt, get out. He's trying to be held in contempt. I think that he can appeal or something, or there could be a mistrial or something to that effect. I really don't know how the law works. But he seems to be trying to get a mistrial. That's his goal here. It's crazy.
Able to raise those types of issues.
And she has
present
not held him in
closing
contempt
argument
yet.
Based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin,
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this
On notice.
insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you And if you keep insisting on that, sir, that will be in direct violation of the court's direction.
So
to
they
you.
can't even know that I got a shock device on my ankles.
They absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Mr. Brooks, your custodial status is not on trial here.
I would
No,
argue that it
your
is.
conduct from November 21st.
Death
of
their oath.
2021 is
That
what
Death
hasn't
their
been
oath.
proven.
I agree. That would be funny as
You
hell.
may not bring up the way that you've been shackled. It's not relevent, sir.
It's
and if
the
you do
truth.
so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specific.
It's my right, though.
Let me go. Okay.
It's my constitutional
is-
right. Just like
are
under the
certain
First
things
Amendment,
I
which
mean,
preserved
if you
my First
want to
Amendment
like
right when I
shoot
came in
yourself
this
in the
morning, I
foot
also
with the
preserved my
jury,
Sixth Amendment
knock
right.
yourself out,
Please
dude.
stop. You do not have an unfettered First Amendment right. That is very clear based upon.
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are.
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not.
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct
land.
Your attention to closing instruction 460.
I'm
which
going-
will be
I'm
read
Because
going
he's
the
trying to
jury.
gain
let the jury
sympathy.
know
It's
the
an
truth.
attempt to gain sympathy with
Their
the
duties
jury.
and their
Michelle
rights.
Macklin.
Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't, no state law can override that.
Mr.
any
Brooks,
law-
do you intend
any
to
law
keep this up when the
repugnant-
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
not-
before they come out. That's why I'm trying to address this before they come
Repugnant.
out.
Repugnant,
So it
I
doesn't
tell
become an
you.
issue once they're in here.
Repugnant.
But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started. I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that.
But I know
But
more
any
than
law
you, Judge, about
repugnant
the law.
of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can
Null and
also,
in void.
forfeit by your conduct the right to present a closing argument. In appropriate circumstances,
So,
right
okay,
to present
this
a
is
closing
interesting.
argument, no different than the right to testify.
So she's about ready to just be like, you don't even get to give a closing argument. You don't even get to do that. That's where she's at right now. She's about to just lay it on him and be like, nope.
maybe subject
And
to
basically give the entire closing to the prosecution.
forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to.
She
as
has not
civility
displayed at
in
all.
the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of
The Wilson
procedure.
Dallas.
Well, you have a
Is she a
right to
doctor?
present relevant and
Does she
probative
have, like-
arguments to this jury.
She has amazing
You may
patience.
not.
Are her
And
patients
you may
superheroes? Are they
present
are they
arguments
Spider-Man?
related to such things
I'm
as
sorry, I've just
jury
busted your balls.
nullification subject matter jurisdiction, the court's
I'm just
oath
messing with
or
you.
lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to
Michelle,
Heron
maybe
versus New
she's
York,
just not,
422 US 853 in 19.
I would say that's her choice, I
Although
guess,
in a
is to
footnote,
have the honorable or not in front of her name.
It
Hearing-
does
hearing
stand for the
versus New
proposition
York.
that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting state Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify.
Cherry, what
set
she's
up
doing
reasonable
is
restrictions so as
being
to,
thorough. That's what
meet all of the goals.
that's
that the
what
court
people who
needs
get
to
shit
meet,
done do. Just so you
are
know.
will be as follows, and that is,
Take
again,
note.
sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is.
As
You
it
must
is,
base your
dude.
Closing arguments
As
on the
it
facts that
is.
have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information.
I'm the
Either
only one who
party
gets
may
to pick
vouch
on
for a
Cherry,
witness
Chrissy
or
F.
otherwise
Nobody
express
else
personal
does.
belief or
I'm the only
opinion
one.
regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein.
Oh shit, I made Cherry cry. I'm sorry, Cherry. Now I feel bad.
So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to
I'm
keep
the bad
issues
guy.
properly before the jury, may advise you during your closing argument to
Like,
move on.
can you tell that
If
I'm
you do not
just joking and I don't really give a
honor
fuck?
the court's rulings, then you will run the risk of forfeiting
I love
your
you,
right
Cherry.
to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete
It is on the record.
instructions that I need to complete to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instruction.
In short, shut the fuck up.
Read 160. closing
Shut the fuck
arguments
up
of the
until
parties,
it's your turn to
and
talk.
then to have the state go first as they bear the burden of proof.
Now, Your Honor, I just let you make your record. I didn't overtalk you. I didn't interrupt you.
You're doing
Yeah,
that
fair to say.
now.
I let you make the record.
Oh, I let
With
you.
all due respect, when will
I
will
let
be able to
you.
make the record, as I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
And you're going to your
Denying
room.
request to make an offer of proof regarding your appeal. It's
So,
not. I am
I'm
not
not allowed to
required
make the
to give
record
you
at
that
all, Your Honor?
opportunity, sir.
I'm not allowed
Sir.
to make the record at all, as I just let you did, because some of the
Sir,
issues
I
has
have.
been some
You
of the
have
issues
told me
has
what
been
you want to do. I've
Your
told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I
I'm
did not
sorry,
do that.
Cherry. I'm sorry.
Even though everything that you
I
said,
take it all back.
you have
I
not proven for the
promise.
record, and it's unlawful law. You haven't shown one time that that is lawful for you to do what you've been doing as
Mr.
far
Brooks,
as your rulings.
once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to
Your
make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue you want on appeal.
I'm going
Yep.
to inform the jury of the truth, their duties, and their rights, as I have the right to do under the First Amendment and under the Sixth Amendment. You can't just
Look at you see that
disregard the
shit?
United States Constitution.
Do better
You
than
can't
that,
do that.
dickhead.
Again,
You
any
see
law
that
repugnant
shit?
of the United States Constitution. is
Y'all act
null
like
and
I'm
void.
the aggressor. Okay?
There's no state
I'm the
law that you can
protagonist
cite.
here.
There's no federal law that you can cite that overrides the United States Constitution. You
Mr.
know
Brooks, I
this.
direct your attention to State versus Anthony. Although that case dealt with the right to testify.
Okay, so
its
we're not
reasoning
talking
is
about the right to
equally
testify.
applicable.
We're talking about the closing arguments, correct? We're not talking about testifying, which you
Mr.
already
Brooks,
made a
I'm not
ruling
going
on.
to delay
You
any
already
further
made
the
a ruling
closing
on.
arguments
But
of
Your
the
Honor,
parties.
with all due
I will
respect,
address your further request.
with all due
once the
respect,
state-
you already made a ruling.
With all
about
due respect,
testifying.
I'm going to
Did you or did
continue
you
to
not?
disrespect you.
Mr. Brooks.
So we're talking about now. We're talking about closing
Oh
arguments.
my
that
God,
I said,
this dude, bro.
it's my right to be able to
Dude is the
inform
worst.
jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
You
we are
can't
at the stage
tell
of
me
the
I can't-
proceedings where it is the state's burden of proof where they get to make their closing argument.
We're talking
first.
about me though.
I understand that, sir, but
I'm going to inform
your
them of the
conduct
truth.
right now is delaying
I'm not intending
the court's
to delay
intention
anything.
of moving
I'll let
forward
you,
with
Your
the
Honor.
closing
I
argument.
just sat there and let you make the record.
This
I
guy
didn't overtalk
sucks.
you or interrupt you. I let you
This
say
guy
what you wanted to say.
sucks.
I let you make the record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by
I'm not
going off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues.
Bring the jury in.
From my
How am I-
perspective, that is in an
How am I
attempt.
being dishonest?
Bring the
How am I
jury
being dishonest?
in.
How am
So
I being
you are
in
put on
dishonor?
notice. I am done dealing with
How am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have
I'm
I
not
not
going to
preserved my
address
rights?
Oh my
further.
God,
Have I
just
not
bring the
preserved my
jury
right?
in.
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under
Woo!
what lawful law can you do that?
Under the
Sir,
one that
I've
You
made
can- you
my
can
I went to
determination.
law school to
Attempt.
learn.
By Illinois versus Allen, you can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments. but
Apparently
you
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
because all I said was it is my right under the
Oh
First
my
Amendment
God,
and the Sixth Amendment
dude.
to inform the jury of the truth, their rights and their duties. I never once said anything
Look-
about,
look-
oh, I'm gonna bring up subject.
Look at
matter, or I'm gonna
BHB
bring up
behind him.
this,
Sir,
He's
and
or I'm
I will
pissed.
gonna bring
wait
up
and
that.
see what you have to say, but I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're not
day, though, Your
relevant.
Honor. This
They're
is a
not-
whole new day.
That it was prudent on my
Oh
part
my
to give
God.
you some guidance before.
And judges don't use gavels anymore.
Do that in
Like,
front of the jury.
I haven't
Okay,
heard
but-
her
I will
pound a
wait to
gavel
see.
Your
once.
Honor, it's
Is that
But
like
I need to
obsolete
get
now? Do
going.
they
it's
not do
still
that
and I'm
anymore?
going to,
unconstitutional for
sir.
you to
So-
tell me that I
need
don't
to
have
be
the First
quiet.
Amendment right that
You need to
I
shut the
preserve,
fuck
or
up.
the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to
preserve,
have the jury brought out. I expect that you will be
There you go.
respectful,
There you go.
courteous, and quiet.
or I'll
There
be
you go.
or I'll be
When
held
this
in
door
contempt,
opens,
or I'll be held in
if you
contempt.
insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what
And
lawful
you'll build
law?
a fort.
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you
Oh
can,
my God,
and
dude.
you don't
Shut
have no
the
lawful law to
fuck
do that.
up.
We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now, because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even,
coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say
There's
that you
no
can utilize
unlawful
the mute
law
button?
that says you
It does
can't
not.
mute me.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet.
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you to,
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public
The
servant.
jury's coming
You're
in.
supposed to serve the people.
Jury's coming in.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt.
Thank you,
Hold me
Cat's
contempt.
Crazy Life. He is ruining her
Hold
timeline
me
now.
contempt.
She is pissed off. Yeah.
I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings,
Your
whether
Honor,
he
I
agrees
haven't-
with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights.
I wonder if these are
under the
family members
Constitution,
behind him
under the
right
First
here.
Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm not
the way that you have
disrupting
through the course
proceedings.
of
You just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed
I
that
am
the jury. I'm
asking
informed
you
that the jury
To
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The
satisfaction.
record
It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you going
follow
to
the
answer
court's
questions as a
Dude,
public
just
servant on why you're
fucking
making up
tase
laws
his
that are not
ass.
in the
Like,
Illinois versus Allen?
dude,
It never utilized a
homeboy,
mute button. It never
behind
said
you.
anything about a mute button.
Just fucking
It is
tase him,
clear
dude.
Why
that
am I
Mr.
Just
being
Brooks
walk
has
up
tased?
to him
absolutely no
and
intention
put a
of following the
taser to
simple
his
rules
neck
of
and
decorum
put him the fuck
and
down.
courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
I'm
to
glad
bring the
everything
jury
at Law
out
and Crime just
and
crashed.
utilize it?
I'm
He
glad
will
Law and Crime
continue to
crashed.
talk.
Fucking
So, Mr. Brooks, you
Your
have
Honor.
Channel
forfeited your right to
strikers,
be
false
present for the
flaggers.
state's
Is that not,
closing argument.
Your
You
Honor,
will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant,
invite you back over when it's time for
You
your
can't
closing
invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is
I mean,
to
I
be
know you
cleared
can't
so that
tase
Mr.
him. I'm
Brooks can
just,
be
like,
removed to the next
joking, but-
courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom, when I can
and
do
you'll
so
mute me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling over my
right, fit and curvy. I agree. That's where we're at. This dude, I mean, this is going, let's be honest, folks. This is going exactly how we expected it to go, is it not? This is exactly what we expected to happen. This is what he does. This is what he's been doing through this whole trial. This should not be any different. There's no reason why this would be any different. So, unreal, man. Yeah, he feels justified in his conduct. That's the crazy thing. And she's doing everything to make sure that there's no mistrial. Right. It's frustrating, Cherry. I get it, man. It's super frustrating. But the people in chat here, they're correct. You know, she is doing everything, like everything that she says. She is consciously aware that it is being recorded. She's consciously aware that there is a stenographer in there, and she is that stenographer is writing everything down, is recording everything. And she knows how it's going to look to another judge, an appeals judge. She knows how it's all going to look. So she's going for, if I had to guess, I would assume that what she's going for is, I was incredibly patient with this person. I was unbelievably patient with this person. Nobody could have done what I did as far as meeting this person's rights. I exceeded the standard of meeting his rights. I let him take control of my courtroom, practically. Fit and Curvy, yes, I actually talked about this before. You're saying he's also a misogynist who can't stand a strong and powerful woman, and he has a strong and powerful female judge. Right. I absolutely and completely agree with that. I actually made this point a couple of days ago. So yeah, that I totally concur with that assessment. Ali P, thank you so much. The shackles he's wearing under the table are shock shackles. I want to push the button, please. Yeah, I mean, unfortunately, that's only if he leaves the perimeter. If he leaves the perimeter of where he needs to be. At least that's what I'm assuming. I'm assuming that it's kind of like a dog shock collar in the sense that, like, if he gets past a certain point, it shocks him. But I wonder, like, how bad it shocks him. Let's see real quick. No, that's not what I'm looking for. I mean, what would you call that? What's that even called? That. Okay, so these devices have been referred to as stun belts, shock belts, or stun cuffs. Some of the devices which are used to restrain inmates are strapped to the ankle and others around the torso. When triggered, the shock is comparable to that of a taser. It is usually enough to knock a person to the ground, sometimes prompting involuntary defecation or urination. Oh my God, I should not be laughing at this. Supporters of the devices say they deter inmates from attempting violence or escape. Ideally, the devices are strapped on the inmates ideally the devices are strapped on. Shut up, Cherry. The inmates behave and no jolts are needed. But the activation of a stun device depends on who controls it. The critics say leads to episodes in which people can be shocked for nothing more than talking back to an official. In the Tarrant County courtroom in Fort Worth in 2014, Terry Lee Morris was on trial charged with soliciting explicit photographs from a 15-year-old girl. Yikes. When Judge George Gallagher asked him to enter a plea, he did not and said he wanted the judge to recuse himself. Mr. Morris refused to the device on his ankle, and the judge asked jurors to leave the room before warning him that it might be used if his outbursts continued. Mr. Morris again asked the judge to recuse himself, and the Judge Gallagher and Judge Gallagher told a deputy to hit him by remotely it's in quotes, people, hit him by remotely triggering the device, delivering a jolt of electricity. The judge then asked Mr. Morris if he would behave. Mr. Morris replied that he had a history of mental illness. Hit him again, the judge said. Mr. Morris continued to call for the judge's recusal as well as the dismissal of his own defense lawyer. He was shocked one more time before being escorted from the courtroom. Mr. Morris was eventually convicted and sentenced to 60 years in prison. Last month, the Court of Appeals of the 8th District of Texas threw out the conviction and called for a retrial, based on the trial court's improper use of the stun belt. Oh, wow. Okay. See what happens? According to the opinion from Justice Yvonne T. Rodriguez. Okay. So that's the opinion of another judge. That's why that was thrown out. Whose ruling included transcripts from the trial. She wrote that judges can exercise discretion when challenging defendants' breach decorum, such as Judge Jenny here, and threaten to tarnish proceedings with bad behavior. Wow, that's familiar. Okay, so let me read that one more time, folks. She wrote that judges can exercise discretion when challenging defendants' breach decorum and threaten to tarnish proceedings with bad behavior, which is exactly what Darrell, however you pronounce his name, is doing right here. But discretion has its limits, she added. Judge Gallagher said he could not comment on the case because of the judicial ethics, and Mr. Morris's defense lawyers did not respond to the request for comment. Because it often falls to individual counties to buy electric shock devices, it's difficult to track how many are used in the United States. 50,000 volt shocks. Wow, that's crazy. The judge said, hit him again. Is it wrong that I'm laughing hysterically at that
court
shit?
did that because we came out on the record at 2:00 following the lunch break. Mr. Brooks was brought to the main courtroom. And during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met.
Pugs, I agree, actually. I agree with you. It is unusual for a judge, but it's necessary. I don't think it was an accident that she was appointed this case. I don't think it's an accident. I think that she was probably picked for her patience and for her fashion of making sure that everything goes on the record. What we don't want to happen with this case is what happened with the case that I just read about, where this dude was sentenced to 60 years for eliciting sexual photographs from a 15-year-old girl. So he belongs in jail for that shit. But because the judge hit him with the hit him with the shock that he's got around his ankle. Well, it got thrown out. That's it. So she does not want that to happen here. She's probably aware of that case, if I had to guess. But I'm pretty sure that this was I'm pretty sure that this was intentional, that she was appointed this case, because he has probably shown total disrespect to any person of authority whatsoever. Probably bragged about how he was going to handle himself in the courtroom, and she was put here. And I think she's doing a great job. It's a little frustrating to watch, I agree, but her patience is necessary
here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again.
See, she knows.
It is essential to the
She's
proper
playing chess.
administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country.
Dude, that lady got 10
Flagrant
years older
disregard the
in a
courtroom
day.
Of elementary
Look at her.
standards
I
of
feel so
proper
bad for her.
conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle
I
such
agree,
a
Sherry.
stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom
Listen
atmosphere
up.
will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available.
Like a
then.
shock belt.
I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him. He can see us. I've confirmed prior
Yep.
to
Thanks, COVID.
calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom. There's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there, other than the bailiffs, but I'm talking about as a party to the litigation. So
He's counting the cameras.
the cameras in my
He's
courtroom
counting the
include one that
cameras.
would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle, and she is still present within, meaning viewable within that as well. And although I've made
Hell
a finding
no, Brahma
that he has
Ranger.
forfeited
Hell
his right to
no.
be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
No, yeah, he knows exactly what he's doing.
The audio and video are working in the next courtroom, and the clerk's shaking her head. They've done that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability, so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not.
Yeah, I honestly can't wait until he's like, until they're making their closing arguments and he's just pacing and talking to himself, as if he's never paid any attention to any court movie or TV show ever. Oh, my bad, guys. Hold on. My bad.
Viewable. All right, and it should be this similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras.
Objection, Your Honor. I do not consent to being called that. I don't know who that person is.
Maybe a quarter to
Objection.
a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here.
Is he going to do that? I wonder.
In this courtroom.
Catherine, that's actually funny. Is he going to make like a Wile E. Coyote sign that says I object? Oh man, what a farce this is.
Appreciate you asking that I make a record of that. That there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then are you turning off all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Very good. Thank you.
All right, with that, the jury is to be brought out.
Hey, the jury's coming out. The jury's already drunk.
Okay.
Did he, Jimmy James? Jimmy James, I don't know if your handle is a reference to the television show News Radio. Is it? Yes or no?
All rise for the jury, please.
That's your actual name. That's awesome. Yeah, I'm gonna go out on a limb and say that news radio is one of, if not the most underrated television sitcom of all time. Before Phil Hartman died, there was the season with John Lovitz, and it just didn't work.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you at the very beginning of this case was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
And then, clerk, if you would please turn on the PowerPoint.
Yes.
Heather Bishop just quit.
Oh,
I'm totally
hold on
kidding.
1
Don't quit your job. I'm just kidding.
Mr.
Don't
Brooks,
do
do you
that.
have an objection?
That's a joke.
Nothing.
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group.
Don't you
It's
know?
nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodchow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a
Yeah.
client.
Everybody on that
at our
jury should
table.
get a raise at whatever job they
But
got.
rest assured,
having
we
to deal
do
with this.
represent someone. We represent the people of the state of Wisconsin. It's an
Wisconsin.
entity. I can't bring it to the courtroom. People enact laws. People want to feel safe.
There you go.
People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same,
The fact that she
No
even
matter
has
what
to
state-
address that
state or federal.
is crazy.
I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Upper, I'm sorry for the interruption. Your objection, sir?
Oh my God.
Mischaracterization of who I am and the way it was said.
Oh
I
my
feel like
God,
it
dude.
was
You know the jury
Talking
sees
down.
you, right?
All right, your objection's noted. It's overruled. The statement continue.
He can object on a closing
You must not.
statement.
Not.
He shouldn't be allowed to object in a
Consider
closing
anything
statement. I mean, I guess that's how it
about
works. I don't
Darrell
know.
Brooks, other than his conduct in downtown Waukesha on the evening of November 21, 2021.
He has an
Nothing he's done
objection
before
sign.
that. Nothing he's done since that. And you go back to that deliberation. room,
Oh my
please
God,
obey
it's even
Judge Darrell.
printed. It's like
You can find your comments to
It's
his conduct
fancy.
on November 21 of 21. Is he guilty
It's
of
a
the 76
fancy
counts
sign.
that he's been charged with? That and solely that should be your topic of discussion.
Holy shit. Oh
So-
my God.
What are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
whoa.
Mr. Brooks, what is your objection?
Oh my God.
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73. I
Do
believe.
you
And
really
74
want to
and
split
75.
hairs over
Thank
76
you, Your Honor.
counts?
I do apologize. For my math
76
skills.
charges? Really, dude?
68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that mistake.
Whoa.
We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this.
Like, you know, everybody on that jury is going, okay, so 76.
Never.
Got it.
Bail jumping, he was out on bail for 2 files in Milwaukee County, facing felony charges there. He was ordered to not commit any further crimes. If you believe he
You know, like
was involved
a
in
regular
any of the conduct
citizen.
charging counts 1 through 67,
Don't break the law.
you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson.
Wow.
We told the story kind of backwards. We started with the battery for background. First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being?
Aha. There's the intent.
Count 1, Ginny Sorensen.
I like the way she
Count
pitched that.
2, Lee Owen. Count 3, Tamara Durand.
Heather
Oh, I
Bishop,
got-
she just paved the road
Count
for that because
4,
I was wondering. I
James
was like,
Willick. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks.
Now, I feel a little guilty because these are victims, and I
Count
want
3,
all
Count
of their
Matthews.
names
Did
accounted
he
for out of respect
have
for
caused
them.
the death of the victim?
I was
a
talking
victim?
over them.
Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got.
Count 4, Jane Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks.
And he interrupted as she was saying their names. Bad move.
From there, we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't
Dude,
want
that
it,
is
you don't
crazy.
have to have it. But it will be available for you if you ask for it.
That is crazy. Look at that.
And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges.
She hasn't mentioned
Decisions
motive
made
yet,
by
I
the
don't think.
prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember.
See, y'all
you'll
bring up
see 'em
Cherry,
again.
and now she comes back. Thank you
Half of
for
the
that.
vehicles that went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The extreme dance team, it's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The dancing grannies.
Oh my God.
State's Exhibit 54. The formation that they marched in. Who was
God,
located
I hope they
where.
throw this dude under the jail,
recollection of
dude.
how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt. There's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life.
Damn right.
I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Opper, your objection, sir?
Oh my God.
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You piece of shit.
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
Boom! Shut
I
up.
apologize.
Yeah.
We showed you at the very beginning. Remember, our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on,
Get him.
see the officers in the street with their bright yellow vests,
Get him.
see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And
Absolutely.
the parade spectators help us prove it's intentional.
Yes, ma'am.
Your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney
how
Opper.
can speculation be made?
Mute his ass.
Saw?
Mute his
Your
ass.
objection's noted. It's
You're not going to
overrule,
disrespect these
continue
victims no more,
yes.
man. You don't get to
Honking
do
the
that.
horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road.
Yep.
You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street number 15, I failed to include the Catholic community. That's just one of the photographs showing the people.
Yeah, he's
that
not
were
doing
lined up
himself
to
any
exhibit
favors
15
with this jury right now.
from the Catholic
Like,
community
not
of
even a little
Waukesha.
bit. This
There's a lot
jury
of
is already
photographs
like,
identifying
mind
the
is
people that
made
were
up.
marching with that group.
Oh my God. Oh my God.
The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanders back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional.
There you go.
He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this. And he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour.
Wow.
That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going?
Yeah,
How
and you
can
know
hit
they're
2
trying to
and
get out of
keep
the
going?
way.
How can you hit 3 and keep going? Didn't phase him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's intentional.
Mischaracterization of the evidence.
Noted, overruled.
Overruled, bitch.
His conduct when he left the parade route. We'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. that shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that?
Dude, she is
Never
grand
once did he
slamming
say any of these
intent
things.
right
Never
now.
once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story.
Lies.
Does not match up with the known evidence in this case.
Overruled.
Oh, she's not even playing no more. Overruled.
He never
Just
said
shut
that.
up.
State the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please.
Oh my God. A Christmas parade, dude. How much of a shitbag are you? A Christmas parade. Killing people during Jingle Bell Rock.
That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opper.
When he finally pulls into the gas station, he rolls down his window.
I'm so glad the judge is
and
putting a
yells
stop to this.
at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play.
Yeah. The judge just isn't having this anymore. She's just like not even.
The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long are we gonna mischaracterize testimony?
Sir's argument. I've heard nothing improper. Your objection is noted. It's overruled. You may continue, Attorney Opper.
Thank you.
They need to know they can nullify.
That's it.
Yeah, because video
Drives off
evidence.
onto the parade route.
Because video evidence, you know, that's
From
mischaracterization.
this moment,
Come on, dude. Mischaracterization.
right here on Exhibit 15,
Ridiculous.
you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey onto the parade route. Now, there's
Intent.
no doubt for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going,
Oh my God.
hits Deborah Ramirez and her son Isaac spectating
Wow.
on the south side of the street,
What a
keeps
son of a
going,
bitch.
clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body.
Oh my
He
God.
doesn't stop. He keeps going.
Oh my God.
Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen
You
that
piece
were
of
standing
shit.
there outside the steaming cup.
You
They were struck by the
piece
red
of
SUV
shit.
driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them. Keeps going. Gets down here to the end and goes through
Look at all those names.
a Catholic community.
Look at all those names. That is
The
insane.
witness, remember Holly Berg? She testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They look like bowling pins.
Oh my
And
God.
when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like.
You know what sucks is that the jury has to sit through this. They already know. You know what I mean? I
When
mean, it has to
Does
be
the
done.
intent exist?
but-
Doesn't have to be even for a second.
Their minds
I'm
are
not
made
telling
up.
you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks,
She's
I don't
giving
know why.
just the right amount of
Other than-
emotion too.
The rage. He's right. You cannot read minds, neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking, and it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video, way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him.
Oh my God, dude. This is
Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see, if you direct your attention to the left side of the screen,
see
you're going to see him hit Nicole white.
She's showing just the right
Knocked
amount
her
of
to the ground and
emotion.
keep going.
And
Now, if that was the end of the
in
story,
doing so, she's holding
you
back
may sit here
emotion
and say,
to deliver the
Madam
facts.
DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play. Keep watching the left side of your screen.
Oh my God.
Oh my God. Oh my fucking God.
What a son of a bitch.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they supposed to think?
It's proper argument. Your objection's noted. It's overruled. You may
It's, I would
continue.
argue that it's,
Attorney Hopper.
I would say that it's
Mute.
proper.
Shut up.
and
Shut up.
I move
Mr.
for a
Brooks, I've made
mistrial.
my
Shut the
ruling.
fuck
I'm going
up.
to mute you if you don't follow the rules.
I move
Exhibit
for a
one.
mistrial.
Exhibit 152. Clearly intentional conduct.
You're not getting a mistrial, asshole.
Clearly intentional conduct. States Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. This is an excerpt from States Exhibit 154.
Unreal,
Maybe a
man.
little hard to see.
Unfucking
A lot
real.
of that laying in the front part of this photo are shoes. Remember what Dr. Vidritsky said about the shoes and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity, the power.
He deserves to
People
get
were knocked
fucked by a
right
freight
out
train
of
in
their
prison.
shoes.
This guy sucks.
That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
And that's what he's showing the
Excuse
jury,
me.
Dusty Rhodes. That's what he's showing the jury. No remorse at all. And this is
Intent.
one reason why it's bad
What's
to
he running
defend yourself
from?
in a case like this.
What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, States Exhibit number 130. Put that up here quickly. you.
Just think about that. Like, if he actually had a lawyer, he would have
I'm not going
had
to go through
some
this whole thing,
chance.
folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car.
Agreed,
How we
Carmel
tracked
M.
him through the neighborhood. And
Agreed,
again,
Carmel M. I agree.
Desperation. Whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now, remember the interesting thing, folks, none of these witnesses in this area knew anything about what happened at the parade. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled him from keep running, kept him in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle.
I don't mean to laugh.
Every one of these photos.
The windows were down
And
the
it's
whole
that
time, and he was
man.
talking about tints.
And it's that man.
What?
And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin.
But he doesn't go by that name. I object.
In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you
Of
through
course
his
we can, Red
questioning
Sox
of
fan.
witnesses about I'm not Darrell Brooks. And
You think I'm
that's my
missing that
name,
sentencing?
and I don't
Come
know
on.
who that is, and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
Guilty on all counts.
Sorry. Your objection, sir?
Your Honor, with all due respect, I would appreciate the quote unquote language to what does she mean by shenanigans and this and that and the third?
Wow.
Sir, your objection's noted. It's overruled. The state may continue.
Moving on. Shut up.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing
I just-
improper. It's noted.
just
It's
wanted to-
overruled. She may
I
continue.
just wanted.
I'm offended by the
Have an
word
opportunity to
shenanigans.
respond, sir. Please let her finish.
So I can rebuttal.
She hurt my feelings by saying
Go ahead,
shenanigans,
Attorney Alper.
Thank you.
Your Honor.
I'm going to conclude my comments with this, folks. I'm going to show you the video.
I told you this wasn't going to take
together
long.
video of all the carnage caused by Darrell Brooks, and I apologize.
Stitched together.
This is important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls
It's
with the Blazers
necessary.
baseball team
It's necessary. That
And their
is the
coaches.
evidence.
doing nothing more than handing out baseball cards.
Now, I wonder if he actually had a lawyer. Could he have had that
Young
evidence
girls
thrown
in the
out?
Extreme dance team. Can you imagine how
Due to
many
the
hours
graphic
they
nature,
spent
maybe?
practicing that routine?
Could he have
He drove
suppressed?
right through them without a care in the world. The grannies dancing their way down the street,
Oh, and he's
perfect step.
talking over
Every
her.
one of them.
And the judge is letting that go. She's
Catholic community there,
smart.
as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video. But please, I ask you to add up the evidence. Use the map 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please.
76 counts. And
No, I need one more.
she just knocked
Yes,
out
please.
this closing argument like in no time. 76 counts. And she just like bink, Babe Ruthed that shit over the fence.
Go ahead.
And obviously we're not going to see this video. It's too graphic. I have seen the video. I remember when it happened, and I saw the video on Facebook, and I was, I guess, appalled would be the closest thing to it, but still doesn't describe how I felt. I was, and yes, I thought it was a domestic terrorist attack. That's what I thought it was. Something that disgusting, something that malicious. I thought it was a terrorist attack. And it wasn't. It was just an asshole who hates women. No Nothing on his face. Jesus. God. Oh my God. Like, I feel bad for the people that have to watch this. I feel bad for this jury. This is awful. That judge is a saint, man. She's a saint. There's no sound except for the reactions from the courtroom. Yes, the video doesn't have sound, people. We owe it to these victims' families to listen to their reactions, though. No, there's sound. There's just no sound in the video that they're playing, people. Okay? But there is sound in that courtroom. I can hear it. Even though you can hear a pin drop in there right now. But once in a while, you hear a whimper from someone who
Thank you. Before we continue with Mr. Brooks'
is reacting to
closing
this.
arguments, I'm going to take a short break. All rise for the jury, please.
And that was a good move to take a break. That was a classy move. And I'm sure she had to do that just for the sake of her own sanity through this whole thing. I don't blame her. Look at her. She is disgusted.
They can nullify.
You are muted now.
Yeah, she's not doing it, dude. Keep it together. You've been doing great so far. Keep it together, Judge Jenny. Come on. Keep it together. She just had to watch you mow down innocent people like they were nothing. And you expect her to give you any leeway. Fucking shitbag. I'm telling you, this dude deserves to get fucked by a goddamn freight train in prison for the remainder of his days. And I hope he stays alive to have to live through it. And you know, if he had some remorse, I probably wouldn't feel this way. I'm trying to be more empathetic. I'm an empathetic person by nature, but I try to be more empathetic and put myself in someone's shoes. People make mistakes. People do bad things and they make mistakes and they regret them immediately. This is not a case like that. This is somebody who does not care about anyone but his own self and his own self-preservation. And the fact that he would interrupt the jury, or not interrupt the jury, but interrupt the prosecutor during their closing statements, and the jury heard it while she was showing respect and bringing to your attention, everyone's attention, the jury's attention, who these victims were and are. He sealed his own fate. He sealed his own fate. And he deserves anything that he gets. And by the looks of that judge, unless she has a moment where she personally converses with the Almighty, unless she actually has this divine interaction with the Almighty, I don't see her giving him any less than the maximum, especially after everything that she's put up with in this trial. I'm just flabbergasted. And I felt for her so bad when she had to watch that and listen to this guy still have absolutely no even empathy for the people that had to watch it, even if it wasn't you. If you were somebody who has any sense of empathy whatsoever, even if that wasn't you, if you were innocent of the crime, you would not have interrupted. You would not have continued to harass this judge and verbally victimize this judge. Incredible. And I don't know how long this break is going to be. But I'm going to hang out with you guys for a while, for sure. I guess I'll just look over at chat a little bit because I don't have, I think it would be, thank you, 10 minutes. Okay. Thank you guys. I think it would be grossly inappropriate to move over to bullhorn idiot, and start making fun of her and making jokes. I'm not in a joking mood right now. I am disgusted with the audacity of this pathetic excuse for skin, organs, electricity that runs those skin and organs, that allows him to make decisions, that allows him to express himself. I'm disgusted with that pile of garbage, human garbage. And I use the word human very loosely. Yeah, I have one glass of Irish left, and it's right here. One glass left. So yeah. So, whiskey drinkers, let's drink some fucking whiskey. I think we've all earned it. Wisconsin Bronze Barbie. And Wisconsin, like, shit doesn't happen there like that. You know, I mean, I'm sure there's crime in Milwaukee, you know. God, but these people, these are people who you know, their most stimulating conversations that they have with each other are snow shovels. They're about snow shovels and shit. It's crazy to me that they experienced something this horrific. The Frilly Farmhouse asked a great question. How long do you all think the jury will be out? Say by tomorrow morning. Yeah. I definitely don't see this lasting the week. I definitely don't see this the jury deliberation lasting the week, unless there's just a pain in the ass fucking idiot in the jury box that is that is going to turn this into some sort of political thing, which I think the chances of that are slim to none, and I'm leaning more towards none. But yeah, with whatever the fuck happened, with whatever happened with the sentencing of Nicholas Cruz, there's the possibility that the same thing could happen here, but the idea of that I think is very, very very slim. I don't think that's going to happen. Yeah, like, I mean, I like my Scotch Lindy Barber, but you know, once in a while, you know, I gotta have my Irish. Dusty Rhodes, I totally agree with you. This is what we see. Everything is always somebody else's fault. You know, oh, well, you know, it was because I was brought up this way, or because my mom beat me, or because blah, blah, blah. You know, my mom would scrub me too hard when she bathed me. I just don't want to hear that shit. And this isn't even him. He's just like, nope, wasn't me. What the fuck do you mean it wasn't you? There is overwhelming evidence, piles of overwhelming evidence that show that that is you, on top of your Wisconsin issued state ID. Okay? Images of you and doorbell cams and cell phone cams and everything. I don't know if there's a death penalty in Wisconsin. I don't think there is. But yeah, he's gonna get the max. He's not gonna get parole, nothing. You know, justice would be if there was a riot in the prison that he gets sent to, and then he gets trampled by the entire crowd in prison. Just trampled, just run over and trampled, stepped on to death. And you know, I know that sounds real bad, like I'm wishing something horrible on somebody. I'm saying what I've always said on this channel. I'm just being a little bit more emotional about it, but what I've always said on this channel is justice, however it's served, will be just. I truly believe that. I truly believe that whether he finds God and starts doing good with his life for the rest of his life, or if he gets shanked, either one, that's not up to me. That's up to God, the universe, whatever you believe in. That's up to whatever is just. I'm the kind of person that I do believe in something bigger than myself. I do believe in something grander, greater than myself, greater than all of us. I believe in something that connects us all together. That feeling that you have of a connection, whether it be negative or a positive, that's, you know, for lack of a better term, and I'm not making a Star Wars reference, but there's a force that brings us all together in some way, shape, or form. And I'm a firm believer in that, in all living things, the fact that we have to, you know, eat to survive, and all of these things tied into one thing. You know, a 360-degree square, if you will. I believe in this with all my heart. And believing that something is just, even though it may not seem just, and sticking to that faith, sticking to the faith in a plan or a just something grander than any of our understanding brings me peace. Submitting myself in that way brings me a certain peace. Being submissive in that sense spiritually brings me peace. Evil Ash, thank you so much, buddy. Or the hilarious excuse I've heard is I wish I loved my parents, or else I would have stolen the old lady's purse in the first. Right. Okay, so there's no death penalty in Wisconsin, and that's fine. That's fine with me. And like I said, let's say he finds God. Let's say he takes that tenacity that he used to abuse this judge and he uses it for a positive thing. Are you guys going to be prepared for that? Are you going to be okay with that? Because I know I will. I will. I don't have any hatred towards this person. Do I feel comfortable calling him a piece of shit? Absolutely. Absolutely. But he doesn't always have to be a piece of shit, does he? But in my opinion, this man has absolutely forfeited his right, like he has in the courtroom. The way that he forfeited his right in that courtroom, he has absolutely forfeited his right to live in the society that I live in. That's my opinion. Those are my strong feelings. He has absolutely forfeited his right to live in the society that I live in. The society that I may bring another child into. The society that I befriend people and learn about who they are and what makes them tick. The society where I get to say whatever I want and exercise the rights that he was trying to manipulate and say that were being violated. He lost that right as far as I'm concerned. So whatever he does within the four walls of that prison, cool. I like that Edmund Kemper makes coffee mugs. I like that Edmund Kemper records audiobooks for the visually impaired. Good. It's better than him just sitting there and rotting, right? I mean, in theory, even though he did the most horrible things that you could ever think of a man to be able to ever do to a woman physically, and he was just physically dominant in being able to do so. The dude's like 7 feet tall. And to this day, he's doing the best that he can within those four walls. And I'm okay with that. I'm perfectly okay with that. And no, I don't think that he's capable of feeling remorse, Margot. I agree with you on that. And right, Red Sox fan, I'm with you. I'm with you. Okay? Because at the end of the day, I would love for that to be the case. Everything that I just explained, I would love for that to be the case. But if it turns out that he just lays there and gets train fucked for the rest of his life in prison, that's okay with me too. That is perfectly okay with me too. I do not give a fuck. Whatever fate decides is just, that's what I will be fine with. As long as I don't have to stand behind him at line in McDonald's. He doesn't get to do that. He's forfeited that right. I think these people are starting to come back into the courtroom. I can only imagine what people are going through after having to watch that video. And what's crazy is I'm just thinking about the judge, you know. I mean, obviously the families of these victims, but this judge and everything that we've seen her do and the patience that she has expressed, this is something that she should not have to have had to deal with. And her anger was very obvious. So for her to excuse everyone in the courtroom and collect herself, I thought was absolutely necessary and right for her to do. And I wonder if she watched him and the jury watched him react to the video and show no remorse. Okay, yeah, and this is an opportunity for me to fast forward because I'm a little behind. So there's no sound yet, but the sound should be here in a second. So, and he's back in the courtroom. Look at the guy behind him. The dude behind him is just like looking at him with pure hatred.
Or the record should reflect that Mr. Brooks is now present in the main courtroom. Prior to reopening following the break, I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
This motherfucker, dude.
I would like for you to prove subject matter jurisdiction.
You motherfucker, just fucking.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive?
So you also
actually,
have
I
to
did
take into
receive
consideration, folks.
Was there copies made?
Very interesting thought that I just had.
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out.
Now-
There's no
I'm
other
in-
legal arguments I
I'm
need to
informed.
address. with you
Yeah,
at this time.
now
I'm informed
it's
of
all
what you're
over.
saying. I was merely asking, was there copies made of your?
These attempts now
You said
just
written
seem
decision?
malicious. At this point, after the jury
So my
saw that
record- my
video,
written decision
these
has been
attempts of
filed
his
into
to
the
stall
record.
only
That is done
seem malicious
electronically.
now.
You were provided with a written copy.
This is why I say that she was playing chess.
Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide
Because
that to
now
you.
the jury
Is it
is
proven
like,
subject matter
fuck
jurisdiction?
this guy.
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction.
Well, the jury's not
And I
seeing
will
this.
Continue forward.
She hasn't
with
brought the jury back in,
the final stages
but
of
she's
this
about to
trial,
bring the jury in. But the jury saw what they
which I
saw,
hope includes
and they
your
saw his
closing
reaction.
argument,
And
then
they're
the final
waiting out there
instructions to the jury.
wanting to get this
I will hope
over
it-
with.
it
And he's
proves
stalling,
subject
and
matter
they know
jurisdiction
he's
on the
stalling.
record, too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever. Refers to
Yeah, Frilly
Some
Farmhouse, you're
complaint
right. But this judge has
that was
done a hell of a
filed in,
job.
the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you
Please
aware of
be
that?
If
prepared
this
with your
judge does not
closing
have the
Argument.
most
Were you
amazing
aware of
life
that, Your Honor?
partner, I don't believe in justice.
Was that a
Okay?
tacit agreement that
I
you don't
do
have to
not
answer
believe
any
in
questions
justice.
As a public servant.
If this
All rise.
amazing
So that
person
is a
with
tacit
patience is not at home when she gets there and there isn't a life partner waiting for her that is going to
Record reflect the
do
jury is coming
everything
out.
they can to make her life comfortable, I don't believe in justice. I don't have to, Heather Bishop. This is the last of my, yeah. This is what was left over from the other night. That's what I'm saying, Red Sox fan. I hate feet.
Thank you, everyone. Please be seated.
I would rub the hell out of her feet, though. Like platonically, not even in a romantic like way. I would just be like, dude, what do you
I'm not
need?
ready to begin closing argument.
What can I do?
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues
Red
that
Sox
needed to
fan,
be
you killing me.
addressed outside of the jury, as you always say, which I don't understand why the jury deserves.
Mr. Brooks, this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not.
Dude,
informed
if
the jury.
she's married to a guy,
The court has begun
who,
the
like,
instruction process.
if she's
I
married
read
to a guy
73
that
pages
has
this
my
morning,
taste
and into the
in
early
television
afternoon, I
and
have
in
another
movies, like
30 plus
he
pages
better
to
be
read.
willing to watch
They
a
will
Sex in
be
the City
informed of the
marathon
law.
for
Did you
God
inform
knows
them that
however
they
long
nullify
it
the law?
takes.
Mr. Brooks,
He better be willing to do that.
you do not have that
I'm
right
not doing
to
that
request
shit.
that.
Just for the
And
record.
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to, when ready, I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
if
have
they
no
have
right
the
to
power.
make that argument to the jury.
He's
It's
going to
true.
forfeit his
They
right
have the
to
power.
he's going to forfeit his
all right,
right to a
I'm going
closing
to
argument.
excuse the
He doesn't
jury.
have a
They
closing
should know that
argument.
they have the power.
Please
That's-
rise for the jury.
Oh shit. And the shovel is in his hand and he is about to bury himself. Folks, get ready. Yo, real quick, before this jury comes in here, I got to tell you guys, thank you guys so much for watching this here with me. It means a lot. Like, I don't
Thank
have
you.
the
Please
words
be
to
seated.
express it. So thank you guys
Mr. Brooks, you do
for
not
being here
have
with me.
a right to request jury nullification directly from this jury. I direct your attention to the Bajurkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time. And then, of course, you raised that once again while in front of the jury just now. You also indicated you weren't ready to give
The
your
jury's
closing
in the room,
argument.
yes.
Sir,
Now the jury's
the
there.
time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice. So you can't
Here we go.
force me
Here we go.
into a constitutional
Oh,
right.
she's not. Yeah.
Waiver when I have not waived the constitutional right.
And I think that
will
she's
not
going to take
allow
any
you as a
chance that
public
she
servant
has.
to do that.
I think she's
I
going
have
to take
not
any
made a
chance she
choice.
has
So the
to
time has
spare
come for you to present
everybody
your
in that
closing
gallery.
argument.
Are you making a judicial determination that you're denying me a constitutional right in
I have
open
not
court
made such a
on record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what lawful
conduct.
law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference.
Why are you
anything
arguing it?
pertaining to
Just stand up and
rights
give
when
your closing argument,
talking
you
about
State
closing
dickhead.
versus
statements.
Anthony.
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of
the
those that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen.
And I got a
Anthony decision,
PayPal
State
from
versus
Jade.
Anthony,
Thank you,
are two
Jade,
examples
for that. I
of
appreciate it.
cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular
And
defendant.
that was to be present in trial, correct?
The
Oh my God,
right
dude.
to present a closing argument.
Stop
is
stalling,
no
asshole.
Different. Because it is not evidence, it could be said that it doesn't even rank as high as the right
Candy
to
for you,
testify,
yes. When the
which
Letitia
is
Stock trial
guaranteed by
starts,
the
believe me.
constitutions.
Which I
That's
was
happening
denied
here.
the
I'm
right
not
to
prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument.
Last
There will
chance.
be
Come
no
on.
further
Last
delay.
chance.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No,
And the
once.
jury's hearing all
So
this.
let's
Twice.
make that correct.
The jury's
Once.
hearing this.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again, the
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this
There you
jury.
go. Do it.
You
And
were
shut the
brought
fuck
back
up.
over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told.
Do whatever you
informed
gotta
of the
do.
truth. It's not
Do
trying-
it.
Are you
Just
telling
do it.
me, sir, that
It's
you
not
are
trying
going
to
to
give-
let me ask you a
No, hello.
question.
I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me
Soul
finish.
T, I'm not
So
taking
are you
that bet
telling me
because I'm with you.
that you are going
I don't
to
think it's gonna
disregard
happen.
my very clear directive to you to not bring up the topic of jury
For the
nullification.
record,
That's not what
asshole.
I said.
That's why I'm asking
That's
you.
why I'm
I don't
asking.
understand that question because that's not what I
For
said.
the record,
Sir,
are
you
you
may
saying that
not.
shit?
Argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your
You
attention.
just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power.
I love that he
You
hasn't
said
noticed
power.
that
Listen to
the
me, sir.
prosecution
You're interrupting me
never
once
argues
again.
with her.
So I'm
Ever.
going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you
telling
are
you no
going
such
to
thing. I
disregard
just told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkas says and stands for the proposition.
I
that
would
although
say
the
yes
jury
or
has
no.
the
It's a yes
power
or no question,
of jury
asshole.
nullification.
Ah, a yes or
they
no
have the
no,
power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just want
that
them to be
case,
informed.
The
I just want them
Sir,
merely to be
you
informed.
can
That's it.
call it informing, making them aware.
Yeah,
Whether-
they should be aware
You
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That
How
is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that you
power that they
have, sir.
have? I'm not giving a new jury instruction.
That is
That's
because
not what
there
I'm
is
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification before this jury.
inform them of the
It's
power that they
clear.
have.
Okay, like
not
now,
giving them-
telling
Judge,
me
I'm
that
not
you
giving
are
them a jury
insisting
clear
instruction.
already.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though.
let 'em-
Don't mischaracterize what I'm saying.
What?
You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your Honor.
addition to, no, let me finish. In addition
go.
to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is, it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And
There
Your
you
Honor,
go.
we just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to
Just-
change the whole
just
paperwork because I
move
brought that
on.
up. So
Come
you never
on.
intended for this to even be an issue.
Mr.
It
Brooks,
never was
Move
brought up.
on.
And
If you
then
think
when
I
I
wasn't-
raised the issue,
If
Your
you
Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say
then you
that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's
See-
not what I said.
The
She's
record
feeding
should
into his
accurately
semantics,
reflect
man.
that you were
Like,
kept in that holding cell.
Why was I kept
so
in there?
that my clerk could
oh
finish
my God, dude.
Adding a jury instruction that was not there.
76 verdict forms, and it's times 2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
Or
how
you've
did
interrupted
why did
me
I have
repeatedly.
to sit here for that where I could have just went to my cell and had it delivered?
Make
We had
your
this
close-
at the
make
end
your
of last night- at the
fucking
end of
closing
last night
argument,
before
you
you called
asshole.
recess.
I'm not going to
We
debate
had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court.
Yep.
You,
Get 'em.
Here we
you
go
can
with this.
roll your eyes
Here
at
we-
me
because
all
it's-
you want.
It's
Get 'em.
ridiculous, Your Honor. You just stated that they have the power to nullify.
Would you
any
like,
law,
if you would like,
but then
I
I
will
said-
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument
Under what lawful law?
under State versus Anthony.
Boom.
It doesn't
Shut
refer
up.
to that.
State
Boom.
versus Anthony
Shut up.
did not have dealt with
Done.
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir,
It-
but the reasoning
Under State
You
versus
just said right
Anthony, you
there.
nonetheless
fuck.
is
No.
fully applicable.
No, you
because the more
can't change
general
the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
the law,
bench.
sir, but the
She's
general
reading
I
the
know
principle-
law,
you used to
you
be in
idiot.
legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do that.
practicing law from the bench. I
You
have-
are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I would
Allen.
like to make a record. Would you please show the
The S is
courtesy and
silent.
respect?
It's
I will,
for me to
Your
do
Honor.
that?
I will.
All right.
Illinois.
So looking at the Anthony
like
case,
annoy,
all right,
like you are.
and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized 2 distinct ways in which a defendant may give up his rights: waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there. I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part
He's
of a
stalling,
litigant is
Jen
not
Bird.
sufficient
He's
to
stalling.
demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano.
I know, I'm a little heated.
Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus
I've never
Allen,
seen a judge
397,
argue the law
US
with
337.
someone like this.
They went on, the court that is
During
the
a
Wisconsin
trial.
Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing
Daphne, I agree
the
with
guidance
you.
from
It's
Illinois
just-
versus
it's
Allen
frustrating
and
to
State
watch.
versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right.
She brought receipts,
to
y'all.
present a
She
closing
brought receipts.
argument. That is my ruling.
I
Boom.
object to that ruling, Your Honor.
I don't give a fuck about your objection. Shut up. Shut up.
I object to that ruling.
Nobody gives a fuck. Shut the
Are you
fuck
willing
up.
to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have? How is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I've just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at
Well, that's a
549.
lot of-
That's
that's
a
a
Court
lot
of
of
Appeals
cases, Your
case from
Honor.
1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury
It's a
nullification
description,
would run
dude.
afoul
It
even
means
more.
they spelled
And
it the
so
fuck
I am
out.
telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification.
And she has
in
the
any
authority
way.
to do it.
Your Honor, hold up.
Oh, the mask came off. The
I'm
mask
the only
came
one
off.
that has to be made rules for closing arguments, but not the prosecution. How is that fair? How's that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
That
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record, but
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for matter of fact, I reject that ruling and take exception to that ruling.
Nobody gives a fuck, dude.
Your
For the record, may I request a legal or factual
Just
basis
get
for
to
your
the
ruling?
fucking closing
Not
argument,
one
man.
pertaining to
Oh my god.
being
This is-
present in the courtroom or
Dude, this is like
testifying.
jerking off with a cheese grater.
One
This
that
is
specifically
fucking
talks
torture.
about a closing argument.
Like, this is so painful, but I gotta bust my nut.
all of those requests are
Terrible.
noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
Denied.
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it
Man,
before.
Fuck.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm
a
confused, Your Honor,
court of
because
appeals, not this court.
No, this is-
Jesus
I'm
Christ,
supposed
dude.
to be in this admiralty court.
Oh God, I'm
Because you
so
haven't-
glad
you
that I
haven't-
had this one drink. Just
Is
this
the-
one
if
drink
we
that I
were
can
under
nurse
Article
through this
3,
whole
And
thing.
we should be in common law court. That hasn't even been addressed. If we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even need
And
to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Dude.
Sir, I intend to bring this jury out and give you
Oh, the jury is
An
not in.
opportunity
Okay, I thought the
to
jury was in the room
present
already.
a closing argument.
Yeah,
If
but
you
you're
violate,
also, you're
please let
also-
me,
but
sir.
listen,
I
you're
thought the
interrupting
jury
me
was
yet
already
again.
there.
You just tried to put me under a rule that no one else was put under.
I
The
apologize,
circumstances
guys.
require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor.
issue
That's a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules. And
I don't
not
have
place
any more Caribbean
the
Kool-Aid.
prosecution
I
under
don't
the
got any
same
more.
rules.
Sir, the
has to be
circumstances of
fair.
this
That's it.
case and your
This is the last
insistence
of my
on arguing
Jameson.
jury nullification
I
has
saved it.
resulted in
I
this
saved
court
one
creating
glass
this
I
for
rule.
haven't
like
argued it. I
days.
said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that
Oh
they
my
have
God,
the
you're talking
power
in circles
And why
now.
not?
Jury
Why can't they be
nullification.
informed of their power?
because it would violate the Bajorkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury
I'm gonna
out.
I'm
start
gonna
a band and I'm
inform
gonna
them that
name
they
it
have the power.
And
Bajorkas.
if you do that, I will dismiss the jury. and
Who
I
wants
will
to be in my
declare that the
band
right
called
to present
Bajorkas?
a
Can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how
oral,
I've outlined that
oral
to
motion
date.
for a
I'm
legal
not going to
finding of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
present a
I'm
closing
gonna
Under what
do it.
lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I
So I'm
No
being held in
takers?
contempt
Really?
again.
You guys
Is
don't
it
want to be in
civil or
my
criminal?
Bajorkas band?
Sure.
Really? All right, cool.
go ahead.
Well, Queen Ashley's with me. All right, cool.
May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant in his petulance will say jury nullification in the first 3 seconds. The jury's in the
Objection to that.
We know it. We
Proper
know he's gonna do that
thing to
shit
do,
like
I think,
immediately.
Stop
Can we just
interrupting.
tell him to
Okay,
fuck
Ashley,
off?
Talk down to.
allow him to make his closing argument. I will object if he misstates the law, you can instruct the jury to disregard any misstatements of the law.
Careful.
Continue in
Don't tell
that
her how to do her
fashion,
job.
if
Careful.
possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument.
Oh man, I want a
But
Philly
we could at least
cheesesteak.
try
Oh, that's what I should order.
to,
That's what I'm in the mood
by
for. I don't
merely
think anybody on DoorDash around
objecting and
here.
the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument.
Wow,
If
good move,
that's
man. She is
unworkable,
like,
then I think
okay,
this record
let's
will
give
be
this dude a
very
chance.
clear as to the efforts of this court.
She's not even trying to shut him down.
And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction.
Yo,
court
this
could even
prosecutor
give,
is
telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell
right.
them.
Gator
that
Gal, you're right.
closing
You're
arguments are
right.
not
This is a
evidence.
great strategy on the prosecution's
And,
part. Great strategy.
I think they will abide.
Let's
by
give
that.
him a chance to talk to the jury.
So I know.
Let's
it's
get
going
him in
to
front of that
require,
jury.
Effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace.
She does want to
Correct.
make happy, and I don't blame her. She earned it.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom.
I
would be
know,
the second
Platform
step, and
Boots.
then
I'm
there
so
would be
tempted.
forfeiture.
I'm so
I
tempted
object to that.
because we got Instacart. I can get like
Your objection
I
is
can
noted
get
for the
more
record. There will be
Irish
the course of
via
action that this
Instacart.
court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with
She's
that,
trying
let's
to
go
help
over
you,
your-
you
For the record,
fucking
I respectfully
dickhead.
Request the legal reconsideration of your ruling.
Stand up for the jury, you fucking douchebag. Like, look, he can't even
That-
stand up
that's
for the
an agreement
jury.
that you
He's
don't
the
have to
one
answer my
person
objection,
not
right?
standing up for the jury, and the jury's coming in. Smart, dude. Real smooth.
Reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
Denied.
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction
Denied.
under,
The jury's
based on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact?
Denied.
Because I'm going
Yeah.
to inform the jury of their power. They deserve to know.
Vete pa la cama. Pa dormir. Pa dormir ya. Pa dormir. Grandmaster Sid Sophos looking out for me. Clara, put that towards your Tennessee whiskey. You better believe I'm going to do that shit. Except I'm going Irish. That's what's happening. Thank you so much.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks, your closing argument, please.
Báñate y vete para dormir. Ya. Se acabó. Se acabó, papo.
Good afternoon. It's been a long day.
can't take this dude seriously at all.
First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe.
Privy.
And
here we go. Tie the noose.
one
Tie
thing
it.
that I believe
Get it
that
tight.
you have not been privy to is the truth of your rights and your duties, being the jury.
¿Qué te pasa,
The
brody?
fact that you and you alone have the power,
¿Qué me pasa, brody?
not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics.
A lot of
Certainly
theatrics.
not the judge.
A lot of theatrics.
You
Okay.
alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power.
I
to
feel kind of
nullify
guilty
any
because
law
I
that
feel
you
like I
wanna
should
do.
have the prosecutor's energy right now. Like she's not playing
Sustained.
around. She's not
I
happy.
will strike from the record the last statement made by the defendant. The jury will
Which is-
disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge,
All knowledge.
not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with
Oh, Judge.
my opening statements, I don't have a well-prepared or rehearsed speech.
No, of course you don't. We know.
I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart.
Ladies and gentlemen of the jury, I'm just a caveman. I fell in some ice and later got thawed out by some of your scientists.
What you
Your
won't hear me
world
do is argue
frightens
facts.
and confuses me.
And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event, it should be recognized.
Oh, that's a
Trying
bad move.
to argue facts of this, facts of that. I'm not gonna waste your time doing that. It's a little emotional. I apologize for the long pause.
Oh, here we go. Here come the waterworks. Come on, force them. They're coming. Come on, those tears are going to come, dude. Let's do it. Let's see the tears.
It's hard to keep everything
It's
together
hard to
emotionally.
give a shit when you don't.
And honestly,
Right.
I don't believe that I have any more tears left.
Oh, now the
It's
excuse
hard.
as to why he doesn't show emotion. I love it.
For the families, mostly.
Wow.
That should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal.
This motherfucker.
That opens the door to talk about forgiveness for a little bit.
Oh, now we're
With
talking
every
about
healing
forgiveness.
process, there comes a forgiving process. It's not an easy thing for anyone.
Yeah, everything's about him. That's right, Michelle.
what you've been hearing from the prosecution, not to take
Right,
anything
SF
from
investigates,
anything away
right?
from them, but let's call it what it is. You've been hearing a lot of
Rerun.
same things over and over and over. No different than
Rerun.
when
Huh?
you turn on the radio and you first
Y'all know
hear
what I'm
that
talking
song
about.
that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing?
What? You totally rehearsed this in the mirror,
That's
by
what's
the
been
way.
happening.
You
Rerun,
totally
over
did that.
and over and over and over and over and over and over.
Yeah.
Attempting to make things stick in your head that simply aren't true.
I can't believe it.
Why do I say, what am I saying? I say, look at the testimony.
Okay, because
The
some of the
thing from
testimony went
the
in his favor a
prosecution
little
here
bit.
has been intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves.
Oh my God, if he raps, please let him rap. Please let him rap.
How can you look in somebody's head and say,
Please,
this is
sweet,
what they intended to do?
sweet dear baby Jesus. Let him rap.
You know, for a year, I've sat and gone through this.
It wasn't me.
Feeling so powerless. Letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that.
Wow.
A lot
Wow.
of it, there's
You
no need to get
motherfucker.
into. I myself in my own life have had to do a lot of healing.
Shock him. I say shock him. Fuck him.
As a man with children myself.
Oh my God, he did not just fucking go there. After the defense, after the fucking evidence of how he got those
I find it
children.
hard to believe that anyone who's really had conversations with me, spent time around me.
He's trying to force those tears.
For 1 second,
They're coming. You got to give it like 10 minutes.
that this is an intentional act. I've never heard of someone intentionally trying to hurt
He's
someone
absolutely trying to make himself cry.
while attempting to blow their horn.
Come on, come on.
Well,
you could bring them. Bring the tears.
Attempting to alert people of their presence.
Okay, so you're
Which brings
admitting
me
that you
to
did it.
More information that I believe that you should have been privy to.
Right, Red Sox fan. Exactly. What's your defense? Intent. You weren't there.
And I'm sure that
you're not Brooks. What?
Will beg to differ. But the fact of the matter is,
no, there's no more argument. This is it. This is it,
the
dude.
vehicle in question, make a model of 2010,
is your mom's.
Ford Escape. The vehicle in question
is your mom's.
Actually, 2008, 2009, and 2010 of that model.
And you were
Was in
driving it.
fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in
Is
fact-
for argument, Your Honor.
Boom!
Sustained.
Was in fact recalled.
Sustained.
Was in fact a class action lawsuit against Ford
Objection,
for
facts
those
not
model
in evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate, not being able to be stopped.
Oh.
It's information. It's
There's an
information.
objection. Hold on.
Nice try, homie, but it's not gonna happen.
Just strike statements by.
Sorry
Mr.
for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's a complete misstatement.
He should have submitted that in evidence.
How's it a misstatement? when
That
I
might
have
have
the
worked.
information?
Mr. Brooks, move on.
God,
This is
it's just you're
information
too
that-
stupid. You're too stupid.
I feel like you needed to know. You should have known.
Alyssa, good point.
Information that was taken away from you.
Taken away.
Why? To prove a case?
Yeah, that's what we're here to do, buddy.
Information that you definitely should have been privy to.
Yeah, prove a case. Right. Oh my God. You know we're gonna have to sit through an hour of this shit, right? And I don't have enough fucking booze.
DA says the defendant has an utter disregard for human life. Utter disregard for human life.
Utter. Yes, you, dickhead.
Not realizing that they're talking about someone that has children.
Wait. So you did it then?
Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did.
So you did it. It was you, right?
Moments that I'll never forget. And yet they say disregard, utter disregard for human life.
Dude, this guy's confessing in his closing argument. His closing argument is a confession, people. Insane.
They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking,
Wow.
why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill. And it doesn't kick in until well within blocks And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed?
What?
Why
They
was someone
were.
with intent to kill and rage try to alert people of their presence, repeatedly honk their horn?
Oh my
You heard a
God,
detective,
dude.
if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years.
Hold on a second. I hate to interrupt this, but listen. The other cases, okay? Other cases that have nothing to do with this one, regardless of who's in my chat, should not affect your feelings of what you bring up and do in my chat. Like, chill the fuck out. Everybody chill the fuck out. Stop. Okay? It's got nothing to do with nothing. All right? Past case is a past case. This is a completely different topic. Got it? Cool.
Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if
This
driver may have
son of a motherfucker right here.
that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people?
I mean, this seals what his defense is going to be. So, and it's all over the place. His closing argument, like his
DA
defense,
played
is
a
all over the
exhibit
place.
17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could?
You did. What are you talking about? You did.
Target people, mow down people.
You did that. Oh my God. He is not helping himself right now at all. Oh my God. Everybody in that jury is just fucking infuriated right now. Holy shit. This guy just fucked himself so bad.
Reference was made to this vehicle, the damage.
Holy shit.
Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. I've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that.
Look at that. Look at these people. Oh my God. And I'm so glad that the cameras are panning to them. Because these aren't even the victims. Like,
so I go
think
back
about
to
that.
Trying to wrap my head around everything that's happened in the last year.
Melissa Bell, totally. Yeah. This case is over tonight.
Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, man, and all the emphasis that's been put on the alleged defendant.
You are fucked.
And the people have been disregarded. Makes me wonder, does DA even care about those people?
Thank you, Caribbean Kool-Aid. I just did. Like, yeah, I'm definitely drinking tonight.
There's been prayers going up every day.
Oh my God.
It's been suffering on both sides.
Right. SF Investigates. I actually agree with you. People are going to be insulted to have to even like
Threats,
interact
hate
with
mail.
him in prison.
Because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school,
Wow.
to be bullied,
Wow. I'm a victim.
for my mother to have to leave her home and stay at a hotel because she's afraid for her safety. Because she
Didn't
gets
come and testify for you, by the way.
hate mail shoved through her mailbox. My nieces and nephews to fear for their safety.
Please, dear baby Jesus, let him ask about the plaintiff. Rhiannon, I'm with you. I want that to happen.
And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8.
He's so manipulative, but he's not good at it. And the jury
Attempting
sees
to
right through it.
Answer her questions that she's
Guaranteed.
asking, and still continue to shield her from what she sees, what she hears. Having a newborn son.
His
that I
babies
haven't
are
even
being
been able to
bullied.
meet.
That's why you should.
Haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation.
Dude, I can only imagine the judge right now.
While still attempting to wrap my head around it.
They're not even showing the judge. You notice that? Like they haven't put the camera on the judge at all.
I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen?
Exactly, Julie Porter. Good point.
Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to.
There's the judge. And she still looks
look at it
empathetic.
from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love. Still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't.
How do you know?
As a matter of fact, it never even crossed my mind to even attempt to ask myself that because I know it wasn't.
Why? You saw the video and it wasn't you. And it wouldn't cross your mind to wonder why somebody would do that?
Sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements.
Yeah, Mr. Smith, exactly. Yeah, that's what he's doing. And this is predictable.
E-books. Everything you've heard in opening statements, everything you're hearing now is from right here.
I didn't write this down. I didn't write this down. I'm speaking from the heart.
You have the decision. You and you alone.
Yeah,
You.
exactly.
You
We've been wasting our fucking time here this whole goddamn time. Oh, this dude sucks.
I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons.
They totally made the decision like a week ago. This guy sucks. Everybody knows he sucks. Fuck this guy.
Remember the power that you have. Don't for 1 second let it be taken away from you.
You are boring the shit out of me, dude. Seriously.
I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure.
You can't understand third grade vocabulary.
I pray that the right decision is made. The right decision.
Oh my God. Did somebody laugh?
It's almost like that a message. Well, not message, but that writing.
I wish somebody
When
from
our
the gallery would
visuals
be
and
like,
you
dude,
got
shut the
red
fuck
mirror and
up.
said things are first and
just
they appear.
just scream it out. Just be like,
But it's
shut the
also another
fuck
way of
up.
saying sometimes things aren't as they appear.
The jury totally zoned out, Marge. You're absolutely right. The jury totally zoned out. They already made their decision.
I can't speak for anyone else, but me, myself, I believe in Jesus Christ.
Oh, come on, man.
That's how I was raised. That's what I believe in.
Oh my God, dude.
None of us are perfect.
Like he just pissed
I
off
try every
like
day
9
to
out of
make
12
sure that
jurors. Easy.
I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go.
He doesn't know any Bible
I even
stories.
read it on
I'm willing to
breaks.
bet
He
he doesn't
says
know any Bible stories. Not one. Not one
this is not
accurately.
something
I
that
guarantee
started
it.
at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised.
I mean, there's nothing wrong with people who believe in what they believe in. I'm saying
Whatever
this dude
mistakes
doesn't
that
believe in that shit.
I myself have made in my life, I've made peace with God.
You haven't made peace with shit.
Made peace.
You can't get peace without accountability, asshole. You have to take accountability. That's how it works. Until you take accountability.
I'm happy to say that my conscience is clear.
Wow. Yeah, those are tears for himself because he knows
And because I believe
his life
I
is
trust him
over.
with my life. Nobody will never know why it was his will for this to happen. A lot of lives were changed that day. Mine included.
Great strategy. Blame God. Good idea. Tell the jury that it's God's fault. Great.
God's way is not our own.
Wow. This motherfucker.
No matter how much sometimes we want to question, we have to have faith.
I'm not even religious and I'm fuming right now. I'm fuming. Yeah, God did it. Wow, dude. Oh my God. I can't even like.
Look inside yourself.
Wow. Oh my. Oh, this motherfucker.
Look inside yourself and make the right decision.
Fit and curvy. That's real. God's like, wait a second. Did he just fucking say? The fuck did he just say? Oh my God, dude, this dude is
Look inside your heart.
yo, in the world of pieces of shit in true crime, right? You know what's happening right now? Chris Watts is handing him the championship belt. He's going, here you go. He's putting Chris Watts is putting the belt around his waist right now.
Everything.
Yeah, let's be careful with those comments. Let's be careful.
It was right. It was right.
Yeah, like they're gonna do it, and they're going to do what's right enthusiastically, dude.
Don't let the smoke and mirrors take away your power. Don't let the theatrics.
That's your
Take away your
job,
power.
actually. Your job was to create the smoke and mirrors, to create doubt of the evidence that the prosecution presented
Each and every
that
one
you
of you has
miserably failed to
the
do.
decision.
Yeah, Ultra
That's
Dark
right.
CEO, you're absolutely right. I totally agree with you. This is not going to take the jury long at all.
Make the right decision.
How many times are you going to say that? Right, Ultra Dark CEO? Excuse me, Your Honor. We don't need to deliberate.
My younger kids getting older and at some point having to explain everything to them.
My Michelle, stop it. I just pictured him getting hit in the face with a head of lettuce right now. Just
Kids don't stay kids forever.
just right across the face, just a fucking head of lettuce just exploding across his face.
And nowadays, kids is frankly a lot smarter than we were when we was kids.
Oh my God,
I'll
dude.
tell you that much.
Shut the fuck up. And then him looking at the judge going, Your Honor, I just got hit with a head of lettuce. You're not going to call a mistrial?
My youngest daughter. And she's still learning cursive right now. So,
oh my
she's the
God.
best
And if he
writer
had
when it
any
comes to
remorse,
cursive. She's got
he
it
would
down.
stop bringing up his kids, because every time he does, he makes life moving forward for them harder,
She said, "Dad,"
more difficult.
and this is from the letter. She said, "Dad, why are people saying all these mean things
Oh
about you?"
my God, this son of a bitch. This guy is using his children right now. The jury sees that he's using his children right now.
I haven't read
Literally
the
using them.
letter yet.
Somebody hit him with lettuce, please. Just one good shot. Like perfect. Your Honor, are you going to
That's what
allow
that
that?
said.
Lettuce? Yeah,
That's
totally.
not the dad I know.
Oh my God. Yo, this dude is making me so mad right now. I'm not even trying to lie. Like, this dude is making me fucking mad right now.
Throughout this year, I've been called a lot of things.
Like murderer? Yeah. Like liar? Yeah.
And to be fair, I am a lot of things.
Yeah. Like a shitbag? Yeah.
A murderer is not one of them.
Yeah, you are. Mass murderer, actually. Correction. Mass murderer. For the
Never
record.
has been, never will be.
The rest of the hour in silence would be great. I wish.
Statements.
Tracy Gilligan, stop it. That is one thing he has not been called is you know, a good attorney. No, he's not a good attorney. He can't even pretend to be one good. Like, it's crazy.
Go inside yourself when making this decision.
Oh my God, dude. How many times are you gonna say that shit? That dumb shit. Yeah, like there's nobody buying that shit right now. There's nobody that's
No fear.
buying into that. Literally nobody. He's pissed everyone off so much. Like they don't want to buy it. That's the fucking craziest part. Is he doesn't
Right.
even have the concept that
You
nobody even wants to fucking buy that shit.
know is right. You know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it.
Ali P, thanks
That's
for
the
being
magnitude
here,
of the power
man.
that you have.
Are you kidding? Thanks for being here. That means so much to me that you guys are here watching this with me and sharing your thoughts. means everything.
Just like this tissue is in my hand. This is everything.
What?
You have everything.
The tissue is everything? Okay. Explain, please. Because I got to know how the tissue's
You have peace
everything.
with what you decide.
Okay, so he doesn't explain. Got it. That's what I thought.
Had no regrets.
No regrets. Translation, no remorse.
Don't let this decision weigh on you after it's over. Hopefully we got a long lot of living ahead of us,
You do in prison.
Lord willing.
In prison.
Don't look back and kick yourself in the behind.
How am I not supposed to laugh at this fucking asshole, dude? How am I not supposed to laugh? Don't look back and kick yourself in the behind. Robert Berg. Hello, Robert Berg.
It took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to basically stop your life.
Oh my God. You're not
Should
helping
be
right now.
commended for
They're
being
mad at
shit
you
over
for
here.
this. They could have
This
gone
amount of
home a
pressure.
long time ago. Or you could have just pled guilty and they wouldn't have
want you
had
guys
to be
to know
there in the
that's not
first
lost on me.
place. You shit
I'm
fag.
sure it's a lot.
That was a typo in my mouth. Shit bag is what I meant to say. I would never use the
You
F
all should
slur.
be commended because
It was-
took courage to do this.
I apologize if I offended anybody. It was not intentional.
I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts.
It was
to
an
do it.
accident, Fit and Curvy. It was an accident. It was totally. Yeah, it was a slip of the lip. I wasn't even
Thank you for that.
thinking the word.
Thank you for taking pretty much a month and setting it to the side.
I would never
Fit.
use that word, Fit and Curvy. Not since I was 13, anyway.
I know it's probably not proper, but you guys deserve a round of applause if you could get one.
Yeah, let's give him a round of applause. That's what we do. Yeah, it was absolutely like not a slur, but a slur.
Thank you, guys.
It was a
Sincerely.
drunken slur, not a
And I know,
you know,
and I
slur.
have faith and I trust that you guys know what's right.
Oh my God, I keep saying that over and over again.
Ladies
dude.
and gentlemen, I don't think it's fair to just say guys, but
No, because there's women in the jury, right? Moms, by the way.
I believe in your heart you know what's right. Thank you.
Thank you, sir.
Oh, everybody's like,
Before I give the stated
look at the
opportunity,
hatred in the guy back here. Like, look at the hatred in the guy behind him.
please stand for a minute. So please stand.
Pure hatred. No, SF investigates. I don't think he thinks that he killed it.
Have a
I
seat,
think
please. And the
I think he
Perez,
knows
his time both
that he
full minutes,
sucked.
you have 13:28 left.
I think he knows.
Thank you, Judge. I don't think that'll be an issue.
Oh, look. Look at the smile on her face. She knows.
Let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy talks about his children. He talks about the
Get him.
hardships
Get
he's
him.
encountered and his family's encountered. And he brushes over the loss to the community.
Get him.
He wants to talk about how he's never held his newborn son,
Wow.
never once acknowledges the Sorensen family, the Owen family,
Not once
The
did he
Darrell
acknowledge
family.
a victim.
the
Not
Hoffman
once.
family, the Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones.
Get him. Mm.
I don't know why he did this. I told you that. But actions define a person.
Yep.
It's
Absolutely.
that simple.
It is
You
that
can
simple.
stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are
Yeah.
that of a murderer.
Address him
You
directly.
murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Hell yeah. I love that she addressed him directly. I wish she would have looked him in the eye, though.
Now, members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you,
Yeah,
the
the
jury,
jury's already back.
selected for this
The
important
jury's
duty.
the jury's already in.
You will not be swayed by sympathy, prejudice, or passion.
Sympathy.
You'll be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional
He's
homicide
awful
while
quiet
using a
now,
dangerous
isn't he?
weapon? Count 2. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty
She's got to
of
go through
first-degree intentional
76 of
homicide
these
as
right
charged
now.
in count 2 of
So-
the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 3 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty
Oh yeah,
of
Ultra
first-degree
Dark
intentional
CEO.
homicide
Now
as
he's going to
charged in
be
count
this
3 of the
pillar
information.
of
If you find the
behavior.
defendant
He's
guilty
going to
of
be this
first-degree
pillar
intentional
of
homicide, answer the following question, yes
an
or no.
example
Did the
of
defendant commit
of
first-degree intentional
perfect
homicide while using
composure
a dangerous weapon?
throughout the rest of this.
Excuse me. Count 4. We
He's going to
sorry,
read
count
his
4.
Bible.
One reading. We,
Right.
the jury, find
Yeah.
the defendant,
Okay.
Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 4 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous
Oh,
weapon?
he's so guilty.
Count
Mrs.
5.
Smith, if
One
he's
reading, we, the
not,
jury, find the
Mrs.
defendant,
Smith,
Darrell
if
E.
he
Brooks,
is
not
not
guilty of
absolutely
first-degree intentional
found guilty
homicide
on
as
all
charged in count
counts,
5 of the information.
well, maybe not all counts,
Another
but
reading,
I think
we,
all
the jury,
counts.
find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous
Fact,
weapon?
not fiction. You're
Count
right,
6.
but
One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty. of
yeah, but
first-degree
critical
intentional
thinker, I
homicide as
know
charged in
Casey
count
Anthony,
6
but
of
there
the
was doubt.
information. Another
There was
reading,
doubt. There was
we,
a
the
that was a
jury, find the
way
defendant,
more
Darrell E.
complicated
Brooks,
case.
guilty of first-degree intentional
Okay,
homicide.
she's just
as
gonna keep
charged in
reading
count
through this,
6
so
of
I'm
the
gonna
info-
mute. But yeah, you're bringing up Casey Anthony, critical thinker, and that's not exactly a it's not a good example, I don't think. Because yes, we all knew that Casey Anthony was guilty. That was true, but there was a lot of doubt that was created by the defense. I mean, there was the whole, was the dad molesting her? Was he not molesting her as she was a kid? Why did mom flip-flop? Mom flip-flopped. Casey Anthony's mom flip-flopped. So that in and of itself created doubt. So that's all they have to do. All the defense ever has to do in a case like this, in a criminal case like this, all the defense has to do is create doubt in one juror. So all it takes is for one juror to go, I'm not convinced. I'm sorry. I'm not saying that he's innocent. I'm just saying you're not convincing me that he's guilty. He's not totally guilty. You see what I'm saying? That's all it takes. One juror. If all 12 jurors don't go, he's totally guilty. If all 12 of them don't do that, you got yourself an acquittal. That's it. It's over. He walks. So the difference between Casey Anthony and this case, I don't feel like there's any doubt. Like, he's on camera. The windows are down. The closing arguments from the prosecution were incredibly overwhelming. And she did an amazing job delivering that, because he did such a good job distracting everyone from the facts with his shitty, fucked up behavior throughout the entire trial. But it was on her. She knew. This person knew. This prosecutor knew. This is what I'm going to have to do. When the time comes that I have to give my closing arguments, I just have to lay out the facts, plain and simple, and I have to keep it short enough to where I don't bore the fuck out of them. And she absolutely did that. She did it 100%, 110%. It was amazing. So then he goes up there and acts like he's Mother Teresa, and it's not flying. And he used his kids to gain sympathy, kids that are going to have to grow up with the fact that he's their dad. So the jury already feels more sympathy for them than they do for him. And then on top of that, he didn't mention one victim. He didn't mention one victim's name. He didn't express any type of empathy for any family member of any of these victims by name. Not once. This dude does not give a fuck about anybody but himself. And not even himself, just his own self-preservation. He has the instinct to survive like a rat or a cockroach. Period. Fuck that guy.
If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 14. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 14 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 14 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
Dude,
Count
he
15.
basically
One reading, we the jury find the defendant, Darrell E. Brooks.
He basically admitted. He basically confessed in his closing statement. He basically confessed. He said everything short of I did it. And he sat there, well, they didn't prove intent. They absolutely proved intent. Because if you're mowing down people in a crowd and you refuse to stop your car and you fail to present evidence early on in the trial saying that, I mean, he never presented a defense. He never presented a defense. So we're talking about all of a sudden, out of nowhere, it's an act of God because the car is faulty, because they've been recalled. And this is where the prosecution objected, and they were like, no, he never presented any evidence saying that this car was faulty. The jury needs to disregard that statement. And rightfully so. And the one thing that might have worked for him, because if that's true, and that's only if that's true, only if you can actually prove that. But he didn't present any proof of that. He just said that the cars were recalled because they were faulty. And he never mentioned that once in the trial before this. Not once.
Of first-degree recklessly endangering safety as charged in count 18 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 18 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering
And he's
safety
awful quiet
using-
now, isn't he? He's awful quiet and awful composed. He's very well behaved all of a sudden, isn't he? Why isn't he arguing with the judge? Why isn't he objecting to anything that she's saying? Even though he never had grounds to object to anything prior. But now he's sitting there with his face in front of a Bible like a choir boy. He's organizing everything. He's doing everything extremely carefully and extremely composed. He's organizing things. He's put his Bible back in front of him.
Answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety?
Now, see, everybody's like 1 hour, right? Let me check. Let me check this. I set up a question to ask you guys. Actually, this isn't going to tell me anything. But most of you guys said like an hour, right? Most of you guys said like an hour that it would take for the jury to deliberate and come to a decision. I think it's going to take longer, but only not because I disagree with why you think it's only going to take an hour. I'm simply talking about the logistics of it all. Listen to how long it's going to take her just to read off what they have to decide on. That's why I got her muted. We already went through this. I actually I was live earlier and I cut the live off because it took her forever to go through this and to go through the instructions for the jury. So 76 counts she has to read off and say, you have to come to a yes or no. And I'm not going to sit through that. And so the jury has to deliberate on 76 different counts. That's why it's going to take a while, folks. That's why it's going to take a while. And she has to do it, right, Fit and Curvy? She actually has to do it. It's just due process. It's how it works. It's the same kind of due process that we go, oh my God, why? Which is the same due process that we have to wait for them to collect enough evidence to arrest Leilani for Quentin Simon's murder. We just have to wait. That's just how it is. I'm not happy about it. I'm no more happy about it than Butthead BHB. I'm no more happy about it than her or dipshit Dolly. I'm no more happy about it than him. But I understand how the law works. Because what happens, what they're thinking about, what law enforcement is thinking about right now is collecting enough evidence to where they can get her in a position just like him to where she can't do jack shit in a court of law. She's not weaseling out of it. She is going to prison and she's not getting out. And that's all they're doing. They are building a case to present in a room just like that to where Leilani cannot fucking weasel out of it. And the only thing close to it that she can come is by creating a fiasco the way that he's done. Okay? So we got to wait. We got to wait. We don't have a choice. It's just how it is. These things take time.
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 26 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 26 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Exactly. Red
Count
Sox
27.
fan.
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 27 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 27 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
What's up, Scott
Did the
Joyce?
defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 28. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 28 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 28 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 29, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 29 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 29 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 30. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 30 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 30 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 31. One reading, we the jury find the defendant, Darrell E. Brooks.
What
not
are you
guilty
confused about,
of first
Cass?
degree recklessly endangering safety as charged in count 31 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly
Yeah,
endangering
let's chat.
safety.
I mean, she has to go through 76 of these, so let's chat a little bit. So Cass says that she is confused. I'm curious as to why, and it's not an attack. I'm just curious. I want to be able to help. You're not dumb. I don't know. I don't know what the fuck I'm talking about. You know what I mean? Like, I just been following this, so maybe I can answer your question, you know? No, you're good, Cass. It's all good. Well, in hopes that maybe I can answer your question without you asking it. What's going on right now, just a little update, is they just gave their closing arguments. The prosecution knocked it out of the park. Everything that's happening right now was already expected, considering his behavior, considering his lack of defense. So I'm pretty certain that now basically when he was up there, his closing arguments turned out to be a grift for sympathy, and it didn't work out. And now he's sitting there defeated. This is a defeated Darrell Brooks, folks. And yes, she's reading jury instructions. She's kind of reading jury instructions. She did the short version this time. She did that. She actually spent half the day doing that earlier today. So because the jury's leaving the room. Ausane, the jury's leaving the room. So just like when the judge comes in the room or leaves the room, everybody stands. But he's not standing. So he's not showing the jury any respect. He hasn't shown the jury any respect.
When you're ready, have a seat. Count 33. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 33 of the information. Another reading, we the jury.
Oh, and I
find the
see what
defendant,
might have
Darrell E.
confused
Brooks,
you. Maybe
guilty of first degree recklessly endangering.
Well, I don't know. Maybe the jury wasn't leaving. I had it muted, so I really don't know why everybody stood up. But Cass, she's it sounds like she's reading the verdict, but she's not reading the verdict yet. They have not deliberated. The jury has not deliberated yet. She's just reading that these are the counts, and the jury, she's instructing the jury to say yes or no. They have to vote yes or no on the things that she's reading off right now. Tommy Dahlstra, thank you so much. Glara, you made this day at the accounting office not be so boring. Thank you from another Miami born. Go Canes. All right. Yeah, I'm a Gators guy. Okay. I'm a Gators guy, but if I'm not rooting for the Gators, I'm rooting for the Canes. Okay, Tommy? Or Tammy. Sorry, Tammy. Yeah. So thank you. I appreciate it. But yes, I'm definitely rooting for the Canes if I'm not rooting for the Gators. It's My brother graduated from UF. I'm a Gator for life. We're a Gator family. That's how it is now. And what I say doesn't matter because I don't even follow the players. I don't even follow it. Like, I just like watching the games and I don't give a shit like who's playing or what. Like right now, I'm really into the Dolphins right now. Because they're doing really good. And it's funny because I had this conversation with my brother. My brother knows all about the players. And I was just my knowledge is just basically like, okay, well, the quarterback seems really good. And the the receivers are the best receivers that I've seen this team have in forever. And it's incredible to watch them make these big plays. Like they're making like Patriot plays, like Tom Brady Patriot plays, right? And so it's just fun to watch the game. But you know, the defense could use a little tweaking, and the offensive line just a little less tweaking, but still needs some tweaking. But it's exciting to watch the games. But I could name Hill being one of the receivers. Don't know anything about him. I can name Tua being the quarterback, and it's great. And it was funny listening to my brother explain to me. He was like, that dude Tua is known. I guess he played for Alabama, and he's known for being made of glass. And big shocker, he got hurt. So yeah, doesn't it fucking, man, you know how much that pisses Miami fans off that like the year that the Dolphins are doing good, the Jets are doing good too. That's annoying as fuck. Yeah, Tua's back. And I don't follow these players, man. Like, I don't know anything about them. So it was cool to talk to my brother and him give me all the history because I'm watching the games, you know? So, like, and then I talk to my brother every now and then. He calls me up and then I was telling him that I've been watching Dolphin games, and he was like, oh man, he's just got in this whole rant about it because he's always followed sports real close. And he got into this whole rant about Tua and Hill, and I think he said that Hill is the fastest receiver in the NFL right now, and the Dolphins have him. That's insane. That doesn't happen. The Dolphins don't get the fastest receiver in the NFL. That doesn't happen. People have thought so my whole life, Lindsey Smith. Yeah, and he's richer too, by the way. So, you know, I mean, he's married, but good luck. Who's in the major league playoffs? And what's funny is I like baseball more than anything, and I haven't followed baseball at all. Please tell me the Cardinals are in the playoffs. That would be fucking fantastic. That would make me very happy to find out that the Cardinals are in the playoffs. And if the Cardinals are in the playoffs, I will fair weather fan the shit out of that, and I will like I will watch every game. Astros, what? Okay, yeah, Cardinals are out. That sucks. So the Astros and the Phillies. I'm gonna go with the Phillies. I want to see the Phillies beat the Astros. Well, critical thinker, not to be a dick, but I got to correct you. It's not the Leilani case. It is the Quentin Simon case. Okay. I want to keep the victim in mind. and he's a 20-month-old boy, or was. But yeah, things are. There's going to be some. There's going to be some coverage from this channel regarding that. Like I said before, hours ago when I started this live, Morbid Reality and I are going to join forces and shut down some of these grifting shitty channels that are exploiting this little boy and obstructing justice for him. Because when you're going around and you're interviewing neighbors and you're not qualified to interview anybody, what you're doing is you're tampering with potential witnesses when the time comes to be in a room like this that we're looking at. And I do not tolerate that. I want that little boy to have justice. So, and I'm going to do everything that I can with my voice and my soapbox to make sure that he gets it. Yeah, well, stay tuned. Keep watching. Keep watching and subscribe to Morbid Reality. Him and I have very we have a controversial fashion about us. That's something that we have in common, but we also have kind of a very similar track of morality as well. Yeah, we're gonna piss a lot of people off.
47 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks,
I'm gonna keep
guilty
this
of
going.
first degree recklessly endangering safety as charged in count 47.
Give
of
me
the
a minute.
information.
I'm just gonna keep this
If you find
going.
the defendant
Talk amongst
guilty
yourselves in
of
chat. I'll
first
be right
degree
back.
recklessly
I
endangering
think
safety, answer the following
my
question,
delivery
yes
got
or
here.
no.
Cat's
Did the
Crazy Life,
defendant
thank you so
commit
much. Let me
first
see.
degree
I really
recklessly
love that you
endangering
never give up
safety
on
while using a
Sophie and
dangerous
Michael, and I'm
weapon?
not gonna give up on that.
Count 48.
Thank you. I
One
appreciate
reading,
that. That means a
we, the
lot.
jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 48 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 49. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 49 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 50. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 50 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 51. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 51 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 51 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a using a dangerous weapon.
I'm sorry about that. When I got out of range, it must
One
have
reading,
paused.
We, the jury, find the
Sorry
defendant,
about that.
Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 52 of the information. Another reading, we, the information.
Sorry
Another
about
reading,
that.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? I think I'll give my jurors one more stand break before I conclude. So please stand, and anyone else in the courtroom, please.
I love how quiet he is now.
You can add them to this
I love how quiet he is now.
if you want these.
And I got a refill. I'm good. I'm good to go. But I'm not staying live. So y'all can watch another train wreck. That's not gonna happen. Yeah, exactly. Let the record show he apologized.
All right, thank you. Have a seat. Count 56. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 56 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 57. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 57 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information. If you find the defendant guilty of first degree
I don't give a
recklessly
shit
endangering
that Queen
safety,
Bee is live.
answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous
Why would I
weapon?
give a shit that Queen Bee is live?
Count 58. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 58 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant
80s
commit
baby,
first degree
it got
recklessly
real.
endangering
That's what
safety
happened.
while using a dangerous
They
weapon?
got him to be quiet because
Count
shit
59.
got real
One reading,
now
we,
for
the
him.
jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 59 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 60. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 60 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 60 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 61. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 61 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks.
Yeah, Mike
guilty of
Talk Show, I'm with
first-degree
you on that.
recklessly endangering safety as charged in count 61.
I'm not going to bet against anybody
if you find
in
the
here.
defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 62. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 62 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 62 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree
This is
recklessly
wearing him
endangering
down.
safety
I
while
love that the
using a
camera
dangerous
stays
weapon?
on him.
Count 63. One reading, we the jury find the defendant.
No, Lindsay
Darrell
Smith,
E.
that's
Brooks,
not going to
not
happen.
guilty of
Like, I'm going to get
first-degree recklessly
food and then I'm going to
endangering
eat
safety as charged in count
and I'm going to find
63 of
something to
the
watch and
information.
then I'm going to go to sleep.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 63
I'm going to have
of the
like maybe
information.
2 of these.
If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 64. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 64 of the information. Another reading, we the jury
Burger
find the
King,
defendant,
K.
Darrell E.
Rochelle.
Brooks,
Burger
guilty
King.
of first degree recklessly endangering safety as charged in count.
I'm not getting
64 of
fries
the
though, because if I get
information.
fries delivered, they're cold by
If
the
you
time
find
they
the
get here.
defendant guilty of
Burger King
first-degree
fries just turn to
recklessly
ice
endangering
immediately.
safety,
It's the
answer
weirdest thing in the
following
world.
question, yes or no.
They're great
Did the
though when they're
defendant
hot.
commit first degree recklessly endangering safety while using a dangerous weapon? Count 65. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty.
I could
of
never get into the
first-degree
blacklist,
recklessly
Fit and
endangering safety
Curvy.
as charged in count 65 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 65 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following
Listen,
question, yes
y'all
or
saying
no.
bad
Did
shit
the
about
defendant
Burger
commit
King?
first
Stop
degree
it.
recklessly
Okay, it's
endangering
delicious.
safety while using a dangerous
I
weapon?
got a Bacon King.
Count 66.
Okay, a Bacon
One
King.
reading, we the
No
jury
ketchup.
find the defendant,
It's gonna be
Darrell E. Brooks,
fucking
not
magical.
guilty of first degree recklessly endangering safety as charged in count 7.
Oh my god, he can't take it
Count
anymore. Look at him. He can't take it
60.
anymore.
6
Are you okay, Mr.
of
Brooks?
the information.
I object to that. No, I don't respond to that name. McDonald's fries are better, except like if
I'll just
they
repeat count
overcook
66.
McDonald's fries for
One
like a
reading, we
second,
the jury find the
they
defendant,
suck.
Darrell E. Brooks,
But when they're
not
perfect,
guilty
when they're
of first
soggy
degree
as hell,
recklessly
oh yeah,
endangering
McDonald's
safety
fries are good.
as charged in count 66 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks,
It's
guilty
delicious
of
kangaroo,
first-degree
K. Rochelle.
recklessly endangering
Delicious
safety
kangaroo.
as charged in count 66 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree
It's a
recklessly
perfectly
endangering
logical
safety while
subject
using a
to debate
dangerous
on, Fit
weapon?
and Curvy. And you know it. Or otherwise,
Count
you would not be
67.
debating on it, would you?
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 67 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 67 of the information.
I like Black Guy
If
TV,
you
man.
find
He's
the
so
defendant
funny.
guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 68. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 68 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no.
This
Did the
this
accident
bailiff,
cause
or
death
I don't
of
want to call him a
Virginia
bailiff. I mean,
Sorensen?
I think he's a
Count
sheriff
69.
deputy.
One reading.
I think he's
we
a
the
sheriff's
jury
deputy,
find the
and he's
defendant,
like back
Darrell
there
E.
just
Brooks,
staring at
not
this
guilty
dude.
of hit and run as charged in count 69.
Like
of
if
the
looks could
information.
kill, man.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or
Fuck
no.
Adam Sandler.
Did
As
the
far as I'm
accident cause
concerned,
death
the
of
only
Leanna
Adam
Coleman?
Sandler movies that matter
Count 70.
are
1 rating, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as
are
charged in count 70
Billy
of the
Madison,
information.
Happy Gilmore,
Another reading, we
and
the
if you
jury
want to
find the
throw in a
defendant,
serious movie,
Darrell E.
Uncut
Brooks,
Gems.
guilty
Uncut
of hit
Gems
and
was
run
amazing.
as charged
And
in
I'm
count
looking forward to
70
the
of
next movie. Like the
information.
same writers,
If you find the
directors
defendant guilty of hit
are
and
teaming
run,
up with
answer
Adam
the
Sandler
following
again for
question,
another
yes
movie
or
that
no.
he says is going to be just as
Did the
intense as Uncut Gems. Uncut Gems was like the most intense movie. I don't know what's going on here. I'm going to mute that, remove it. Yeah, I don't know what's going on there, but I'll leave it. Let's yeah, there we go. Just in case it comes back, something happens. But Uncut Gems is fantastic, and the whole time I was watching Uncut Gems, I was like no, I can't stand Adam Sandler movies, if I'm being honest. But Uncut Gems was good, man. Like the whole time I was just like, dude, stop making bad decisions, man. You're and coming from the guy that is just like, dude, like this is what I do. I make bad decisions. That's what I do. And I'm just sitting there screaming at the screen, going, stop making bad decisions, dude. Stop it. I felt so bad. PJ Fleck show. What? Who's PJ Fleck? PJ Fleck. PJ who Fleck? I think, well, yeah, I think they're just done. Like it's gotten, dude, it's past 7. Yeah, it's past 7. San Jose Sharks going to beat St. Louis Blues this year. I don't know enough about sports to argue with you. I just happen to have this beautiful jersey here signed by Bernie Federko. That was a gift from somebody very special to me. I haven't followed the Blues since I was like 12 years old, but I hope you're wrong. I hope the Blues win. You're already dressed like Adam Sandler. That's funny. Okay. All right. Give me one. Relax. Don't do it when you want to come do it. Relax. Do it. Hold on. I'm going to try to find wait. I don't know if I just clicked on the same one now. Yeah, no, it's the same crap. Hold on. Okay, hold on. Well, I don't want to stream Uncivil Law. He likes to strike people. Well, I don't want to say he likes to strike people, but he's got a bad rap right now because he struck somebody. So I don't want to strike. I don't want to like stream him. And I really want his insight on the critical K thing. So I don't want to piss the guy off. Oh man. Hold on. Let's try this. Let's try a different news station. Look, I found. Oh, yep. There we go. Let me unmute.
Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates, and then I will have all of the civilian bailiffs and deputy bailiffs. that
She must
will
be so
in
exhausted.
charge of the jury during their deliberations. and sequestration.
Dude, I'm not even like psyched to drink this bottle. Like, I'm gonna drink like maybe another drink out of this, and I'm gonna eat my burger, and I'm gonna lay down on my bed and watch something until I fall asleep. That's what's going to happen. It's totally what's going to happen.
There we go.
Like, this shit is exhausting, dude. Every time I cover a case, it's exhausting, and all I'm doing is fucking sitting here. You know what I mean? It's exhausting. When I covered the Joe Clyde Daniels trial, I was just
we have
beat,
placed
man.
one of your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be the alternates, who will nonetheless be
Yeah, sub
sequestered.
to Black Guy TV,
We
man.
need to call
He's
upon
awesome.
one of you to replace another juror.
Fit and Curvy just put a link there. Sub to that, dude.
First number that I
Do yourselves a
pulled
favor.
out
If
is
you like to
10.
see somebody talk shit about somebody and it's funny, yeah, sub to BGTV for sure.
The second number I am pulling out is 30.
Don't say
And the
bingo.
third number
Don't say
pulling out.
bingo.
is 1.
Stop it.
I want to confirm that I still have 12. I know Madam Clerk did it, but I will also do that to be sure.
I bet you she dances to Blister in the Sun when some cover band in a bar plays it. As soon as she hears she's like out there on the dance floor. I'll bet you anything that judges that's what she's doing. I guarantee it. Fucking white people. Like, white people can't resist Blister in the Sun live. It's the weirdest thing in the world.
Just confirm that the other 12 numbers.
White people can't resist.
Go back in and then we'll make a record of that.
It's weird.
All right, then I will need all of the deputies and civilian bailiffs to come up and be sworn on the record for the sequestration. And
Nobody likes that song except your average white person. Your average American white person.
Clerk of Court Taj, why don't you join them just in case you're needed?
Marge, okay, in all fairness, okay, I saw Violent Femmes live, and I would have never paid to see Violent Femmes. That would have never happened. Like, I would have never been like, oh my God, Violent Femmes are coming. I'm gonna go buy a ticket. That would have never fucking happened. But I happen to be going to Virginia, Norfolk, Virginia. And I go there, and the person that I was meeting there was like, I have Violent Femmes tickets. And I was just like, the jerk off song, guys? Okay, sure. Yeah, I'll go see that. And I did. And but they were amazing. Like, they were so good. Like, of course, they played that song last. They were just like, oh, God, yeah, all right. But oh my God, like, the bassist played like this contraption. It was like one string that he was like bending, and like, it was amazing. It was amazing. So yeah, Violent Femmes are a great band. It's just that fucking song, man. That fucking song.
All right, would you all please raise your right hand? Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether
Did you
they
just
have
say
agreed
Tripping
on
Daisy,
their
Nikki?
verdict,
Who the
and that
fuck
you will not,
listens to
before they
Tripping
render their
Daisy
verdict, communicate
since
to any person the
1996?
state of their
What?
deliberations or the verdict
I haven't even heard that
so help you God.
band name since 1996.
Madam Clerk will just make a record of who you all are. It will take us a moment just to have all the finalized paperwork to go back with.
Oh, that tops
Jury.
mine, Calamity Jade.
Have
Or at least
all of the
it competes with
verdict
mine.
forms
You saw the
issued.
Monkees. My first concert, I was 4 years old and I saw Kiss with full makeup. Yeah, 4. I was 4. Okay. It probably explains a lot.
All right, and here are the jury instructions as well.
I wouldn't hate life if my first
24.
concert was Poison,
All
though.
rise for
I
the
liked
jury as they're
Poison.
excused to begin their deliberations.
Kay Rochelle knows I liked Poison. She knows that.
We'll make a record of what she did previously. But
Yeah, I'm gonna need all of them and then I'll
Yeah, no,
tape
I
them
know.
down and all
But
that
those are
business.
the-
Yeah.
I hate Kiss. I think they're terrible.
Thank you. You may be seated. Just so the record is clear, the alternates, of course, will not be participating in the deliberations. They will be in a separate jury deliberation
Oh, the
room
mask. Okay, yeah, the mask
and will only be called
makes
upon
sense now.
if needed, of course, after consultation with the parties. As far as how late I will let them deliberate tonight, we have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire.
The jury's
for
like,
the
we'll
evening.
work
They
all
are
night
under a
because it's not going to
sequestration
take all
order,
night.
So they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else the parties would want me to address at this moment from the state? Anything from you, sir?
Yep. So essentially, I would have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower. It is shower day for my pod. We only get
It's
2
my
shower days.
it's shower day for my
So
pod.
here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that.
No, Kay Rochelle, you gotta
So
you gotta
let me do this.
you-
Let me confer
like-
with the sheriff's department. I don't initially see an issue with that, but
I mean,
wanna
I
make sure
agree
that
with you. He's a
they
fucking piece
have
of
a
shit,
protocol
but
in place, and that's what they would like to do as well. Okay.
like the man
And
can't
one
shower.
more thing.
You know what I mean?
I was
Like, let him
I was
shower for
curious.
fuck's sake.
61 charges for the reckless. 61 injured parties did not testify. So how does that work?
My god.
How
Really, dude?
essentially
Fuck.
how are charges?
Are
able
we
to be
doing this right
charged
now?
if
Are we doing this
all the
right
injured
now?
Parties did not testify.
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would, for me, that would require
I
me
can't
to
believe this is happening
explain
right now.
the law. And
Here comes the
I guess that's all
meltdown.
I can really
Exactly,
say
like
about
all
it
you,
at this
you
point.
guys who put your
I got a
bets
point,
up.
though.
Here comes the
I'm
meltdown.
sorry.
I got a point though.
Here we go. He's got a point.
I'm not going to comment on that, sir.
Thank God that I got another drink.
Of course, the state bears the burden of proof, and they have to convince a jury beyond a reasonable doubt.
Feeling cute might start
For
an
better or for
argument.
worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the close of the evidence regarding any legal arguments you may have had regarding those issues. And so at this point, the jury has the case. And they will
The jury
determine
has the case.
their
It's over,
verdicts.
homie.
There are
You're done,
issues of
son.
law that you want to raise after the verdicts are received. Then you'll have to make that determination.
Yeah, that has to be raised because it's essentially you can't. If no injured party testifies, then it shouldn't be a charge.
It's too
I
late.
disagree with that characterization.
It's like
sir, but
way
there is
too late for
frankly
that.
no
Like it's
motion in
way
front of
too late
me
for that.
based
You're
in law or
reaching, dude.
fact. So for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you saying I need to make a motion?
So what I will say at this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay
I'm so
open.
done with
I
you.
know my dinner is coming. And
My
I think
dinner
it's
is coming.
reasonable. I need
My
to put
dinner's
a few
coming
things
too,
together,
actually,
but
and
I
I'm
do
really
need
excited
to make
about
a
it.
record of some information that I received earlier today.
It's a
that the
big
parties are
cheeseburger with
advised of that,
bacon in
but
it.
I will
Like,
do
I'm
that.
really fucking stoked about it.
Let me confer with the sheriff's department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer.
She just
with
wants
the
to
sheriff's
eat.
department and have a more definitive.
Oh my
answer for
God.
you
Like
shortly, okay?
I would make
Can I get my
her the
flowers?
most dopest batch of spaghetti like
You
ever.
want we have.
I'd be like, just get
want the
fat, baby.
original
You can get fat all you
Madam
want.
Clerk has
Get as
scanned them
fat
all
as you
in,
want. I'm
and
gonna
they're
make you
uploaded.
fat.
I don't have
You
an issue
deserve
giving
it.
You the original
earned it.
back. They will have the date stamp. They don't have a time because they were filed in court.
When he put the time on them. I also, so that they were in there, printed them after I scanned them in, so it has.
Dude, when I'm
can
prepping the
have
veggies for her, dude, I would be
Okay.
like
See, I didn't
surgical
interrupt
about
you.
it.
See,
I would be
I'm sorry?
surgical
I
about
said,
it.
see, I didn't interrupt you.
Thank you. I appreciate that. Unless I would like the parties.
I didn't interrupt, Your
Thank
Honor.
you. Unless
I didn't
they have a
interrupt.
question sooner.
Like she doesn't give a fuck.
Your Honor,
She
do I
can
have to go in
breathe.
that holding cell, or do I got?
She can breathe. She can breathe, y'all. Yo, hit the like for me, but for Judge Jenny, because Judge Jenny can now breathe. Hit the like if you haven't hit the like already. I would really appreciate it. I don't know if he's trying to flirt with her. I mean, I don't know. I can't even tell if I'm trying to. Yeah, no, it's for real, Calamity Jane. She's amazing. She's kicking ass. She got through it. I'm so happy for her that she got through that shit. Like, oh my God. Like, I'm so happy for her that she got through that shit. Like, she just wants to fucking eat and chill. She's earned it, man. She has earned it. She has earned it. Yes, yes, hit the like, people. Hit the like. And she's gonna go scream into a pillow. You know what? You know what sucks about fucking law jobs is the luxury that like food service jobs have is we have walk-in coolers. Walk-in coolers. Let me explain to you guys a little something about walk-in coolers. Walk-in coolers serve the purpose of walking into them and screaming at the top of your lungs. Yeah. If you are in the food service industry, if you are in the bar industry, and there's a walk-in cooler, that is something that if you're an accountant or a lawyer, you don't have, which is basically a soundproof room where you can scream at the top of your fucking lungs. Yeah. Yeah. Oh, guys, this was crazy. And you know I'm gonna be live for when the jury comes back. You know I'm gonna be live for that. You know I'm gonna be live for the sentencing. We're not done here yet, people. So I love you guys very, 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 very much. And I gotta tell you guys before I cut out, I am so grateful that you guys thought that my channel was the one to come to and hang out with while we watch this. I don't know what the fuck I'm talking about when it comes to the law. I don't know anything. I have some common sense in regards to that, but the fact that you guys for some reason felt like this was the channel to come to, I am not worthy. Okay. So thank you guys so much for your support and hanging out with me for fucking 5.5 hours. Anyways, I love you guys very, very, very much. Thank you so much. And we will do this again very soon, my friends.